Pass over for finding. This leg on port number 5.
Orders daily is
Lordship, your service is complete and this is a delay petition, Lordship.
Today, Lordship, I filed the objection, Lordship. Evidently, no objection filed, Lordship. Today. That is the delay. No grounds is there, Lordship. Only COVID, Lordship. The details, the no grounds in the delay.
How many days delay?
They are opposing a delay, Lordship, but they themselves have filed. They appeared when? I think in 22 itself.
325 days delay.
22 and in 26 they are filing their objection, Lordship, and today morning at 10:30 I received the copy.
Yes.
Just to scuttle the 326, I'll explain that, Lordship. But the thing is, Lordship, is their objection itself is very genuine. They are objecting to our 300 something days delay, but their application itself is not genuine because they have waited more than 3 years to file the objection. And that too when the case is listed today for final hearing on the. I don't think it has come, Lordship, because I received it at 10:30. So let it be on another date. Otherwise,
Okay, another date.
Lordship won't have the copy of their objection.
Learned Counsel Ms. Adi Mumde is present for the insurance company, and Learned Counsel Mr. Enamo
Anonymous.
is present for the claimant
Yes.
and has submitted that he has filed objection, which is not on record. Please to place this the objection filed by the claimant on record. List this matter after 1 week, 2 weeks,
Yes.
after 1 week.
Highly obliged.
By the court, Jenny?
Huh? Oh, copy this. Lordship. Lordship, here's the service in our appeal. Our appeal is at top. The service is not complete, and I think in their IA also service is not complete.
I had to song.
My lord,
For
I have for my
withdrawal.
lord.
But
My lord.
Rajadi submission koro, there is a mistake in the order, Lordship, because in their IA notice was sent to respondent number 2. It is the record that respondent number 2 has not come back, but we are respondent number, we are not 3, Lordship. So that correction, the notice has to go to respondent number 1 and 3. That correction has to be there.
In the I,
In the IA, Lordship.
your respondent number 2 in the I.
Yes, Lordship.
Yes, it will be warrant and insurance, it will be diver honestly.
One, yes, one. Yes, we will read this one. Yeah.
Office note, Lordship, shows that respondent number 2 has not, but we are respondent number 2. So, Lordship, the registry has to give a report on respondent number 1 and 3.
Have you taken steps?
Lordship, yes, Lordship, I have taken steps, Lordship, properly, Lordship.
I had to leave us.
Lordship.
Learned
Lordship,
Counsel Mr. Yoni,
yes, Ali.
as Ali is present for the claimant. Learned Counsel Ms. Adi Muzumda is present for the insurance company, respondent number 2. Full stop. The Learned Counsel for the claimant has submitted that steps have been taken to issue notice on respondent number 1 and 3. Full stop. Registry to submit report on service of notice to respondent number 1 and 3.
Yes.
My lord,
The office, an error has, an error is, the order dated, the office note dated, an error now, the office note dated 3/1/2026 reflects an error as respondent number 2 is present before this court today. List this matter after 2 weeks.
Yes, Lordship.
my lord, date may be fixed, Lordship.
No issue. And Lordship, in
Can
the,
be fixed, date can be fixed.
So otherwise, Lordship, we have to pursue the registry Lordship. Lordship, if date is not fixed, Lordship, it is difficult for us.
Hey, Harry, 12 তাৰিখৰ আগত you're leaving, you are going for training after 12.
19th, from 19th, I'm
19
going.
টো আগত দি দিয়ক। 16th
16th of
February.
February.
Lordship, in the appeal also, an order will be necessary because Lordship, office note dated 27/1/26 shows that respondent 2 and 3 not received back it, report, Lordship. And postal tracking not found, flag X, not found or found, Lordship, flag X.
Lordship, my only limited prayer is that, Lordship.
Yes, we'll fix the date.
My lord, already 50% amount is deposited before the registry Lordship. Lordship, I may be allowed to withdraw the same
Have
Lordship.
you given any application?
That
Yes,
is
sir,
the
this is the IA Lordship. This is the IA Lordship.
heard only when the.
This is the IA Lordship. My lord, it is very pathetic Lordship. My lord, that the 18 years old young boy of the claimant Lordship has the Lordship, my lord, died Lordship. My lord, she is still waiting for getting something, Lordship. It is very pathetic, Lordship, that the amount is being deposited in the registry, but I am not allowed to withdraw this. My lord, my prayer is that, my lord,
Who has
the
deposited the amount?
Lordship in the registry of the High Court, Lordship. Lordship, I have indicated in my title page.
The
The
amount
amount
was
also.
deposited, you have deposited.
Yes, sir, Lordship, 5 lakhs,
Allow-
5 lakhs 79,000, Lordship.
That their withdrawal.
5 lakhs 79,000, Lordship. Lordship, date also, Lordship, I have indicated here, Lordship.
Submit.
Lordship.
That IA Lordship, in which the notice they have just prayed that date should be given, Lordship, that is the IA for withdrawal.
But you see, you are already present, so if you.
Yes, Lordship.
It is
Yes,
such-
Lordship.
It is not a question of our presence, Lordship, it is the question of owners present in our High Court.
Our
itself.
presence is not necessary. This is the
Lordship, let
question
me
of
finish, then I'll-
the insurance, Lordship. Since Lordship, money has been deposited in the registry, Lordship, 50% amount, Lordship. Lord, I may be allowed
Why
to do the same, Lordship.
Why are you objecting?
Because, can I submit?
Yes, yes, you can.
Please don't bulldoze. When Lordship, it is not a simple question of, we have filed an appeal, and in that appeal, we have taken a ground that there was violation of policy condition. Already our High Court orders are there, Lordship. In interim also, the presence of the owner is necessary to release the amount, Lordship, because there is a pay and recovery issue.
Okay, all right.
That is the,
Let the notice be served.
yes, Lordship.
Learned Counsel Miss R.D. Muzumdar is present, appeal to Lihiba, he is present for the appellant. And Learned Counsel Mr. S. Ali is present for the claimant. Office note dated 27/1/2026 reveals that service report on respondent number 1 and 3 is awaited. List this matter on, 16 February.
Highly obliged, Lordship.
Obliged.
He's on Kusigolet, yeah. The other side, I think he was present then, but.
My lord, actually, I'm sorry that I was at code number 5.
It's okay, it's okay.
Right.
Let him come.
Right.
We'll wait for him.
My lord, obliged.
The service report upon is awaited upon the respondent number 1 and performer respondent number 2. I shall take fresh steps, my lord. Performer respondent number 2, I shall take fresh steps, my lord.
You'll take fresh steps.
No, I'll
Okay.
take fresh.
Learned Counsel, Mr.
VK Borwa.
BK Burwa. BK or VK?
VK.
VK Burwa is present for the appellant. Service report on respondent number 1 is awaited. The learned counsel may take fresh steps to issue notice to performer respondent number 2. Learned counsel, no, the appellant. The appellant may take fresh steps to issue notice to respondent number 2. List this matter after 4 weeks.
Court.
May it please, Your Lord.
Mm.
My lord, the matter pertains to custody of a minor daughter, my lord.
Mm.
I'm the father of the child, my lord. My wife expired, and after that, my lord, my child was staying with her.
We have the trial court records. It won't be. Kill basic. Scan copy nahi? Okay.
That is the issue, my lord. A petition was filed, my lord, for custody of the minor child, my lord. That pendency of this petition, my lord, the witnesses were examined. They were cross-examined.
Mm.
2019, a petition was filed. Then 2025, my lord, another petition was filed, my lord, seeking amendment, which changes the entire character of this suit, my lord. And the reason, my lord, page 28, my
You are
lord,
praying for an interim order.
my lordship, till the,
But why haven't you taken steps?
my lord, we had taken steps, my lord. Taken steps, my lord. The, on 17, my lord, we had taken steps, my lord, the answered, my lord.
How will it be served if you take steps on 17?
So, December, my lord.
Let us wait for the other date, another date.
Because, my lord, my,
We'll hear them,
even I, do
we'll
not-
hear and dispose it of.
I also not, because it will delay the matter, my lord.
No,
And that is
it's-
why at the very inception,
This is a serious matter, you see.
my lordship.
It is a custody of a child and then you have, this is not a
The,
light allegation. It's a
my
very
lord,
serious
the
allegation.
position of the child will not change, my lord, with, for
No,
this
you see,
particular,
this is a
petition.
this is a very serious matter.
I am the father, my lord.
Let the notice be served. Only one date I'm asking.
My
Otherwise, we will deal with this voluminous record.
My lordship, my, even.
No, you
when the
see,
matter
this
came
type
up, my
of
lord.
thing, this type of serious allegation has to be dealt
My-
with after hearing both the sides. The allegation is serious.
Yes, my lord.
That they'll change the entire
But
suit. You see.
I am trying to put, my lord,
Yeah.
when this matter came up for motion,
Mm.
I never pressed for interim, my lord, considering the fact that a stay of the entire proceeding may delay the matter.
Ex parte order cannot be passed in this type of cases.
Yes, my lord, I
If
understand,
they don't turn up, if they
My
are
lordship.
avoiding to accept the notice,
my lordship.
then I can pass an ex
Because, my
parte
lord,
order.
the trial court is proceeding with
Let us give
the,
one more date.
my lord.
The date is fixed for the other date is fixed for evidence.
No, my lord, that for
date is fixed, no?
submission of amended petition, my lord. I have annexed, my lord, 22/8/25 for submission of amended petition by the petitioner. So that was already allowed. That petition was allowed,
I know,
my lord.
I know.
My
That
lord.
is why you are before this court.
My lord, I'm,
And
with
then
regard to,
now-
I'm aggrieved only by that order, my lord, nothing else, my lord.
And then now,
That,
you see amendment, when amendment allowed
my lord,
to grant stay or to dispose of the entire case,
my lord,
we'll have to delve deep into the matter.
my lord.
We cannot pass an ex parte order lightly and send it back. Or
No,
we
no, no,
cannot
that
pass
is-
pass an interim order.
My lordship, I am not asking for, my lord, my lord, stay of, setting aside of the order and send it back for the trial court.
Only stay.
Only with regard to till next date, my lord, let them come, let them place their case also, let them get a fair chance. I am also getting a fair chance, my lord, by approaching this honorable court. Only limited aspect, because the proceeding is, my lord, has already been, my lord, initiated, my lord. That is what, limited, my lord.
Okay, learned counsel Mr. M.K. Das is present for the petitioner who is agreed by the impugned order dated 7/8/2025 passed by the learned principal judge family court number 2 Kamrup Metro in MIGJ case number 161 of 2019. Full stop. Scan copies of the trial court records have been received. The petitioner is basically aggrieved by the order as the amendment which was allowed has change the entire nature of the suit.
my lordship.
The amendment is at page, which page?
Page, my lord, 49 to 91, my lord. That is the amendment petition.
The amendment which was allowed reads page 49 to
91, my lord.
which part was allowed?
My lord, the original petition, my lord.
9 to 91.
Yes, my lord. 49 to 90, entire, my lord. That is what, my lord. Page number 49 to 91 is their petition, my lord.
No, only the part of the amendment.
Part, my lord, they are seeking the, my lord, entire, my lord, pleadings, my lord. And that was allowed, my lord. That is my grievance. My lord. 49 it starts, my lord.
Just show me the order.
Order, my lordship, will find at page number 98, my lord. Fourth para, my lord, it is there, my lord. Page 98, my lord. It amounts to initiation of a new proceeding altogether, my lord.
The amendment
Indirectly.
which was allowed has inserted new paragraphs as paragraph number 1 to 1 likhi diba, huh? 1 A2 small a within bracket small a to H, and also paragraph 5A
To double F, my lord.
to double F and 6A to
To G.
6G.
My lordship.
It is contended that 49 new paragraphs were inserted, which has changed the entire nature and character of the suit at the stage of what?
My lord, the prosecution witnesses have already been examined, my lord.
Yeah.
PW one of examined,
At the
one
s-
is cross-examined, my
At
lord.
the
Four
stage of
witnesses,
evidence who was progressing, which was progressing,
PW four was given.
full stop. Already PW4 have been, already the evidence of PW4 as prosecution witness has been submitted.
My lordship.
This is evidence in
My
affidavit,
lordship.
no? It appears that there are sufficient grounds to stay the order dated 7/8/2025, full stop. Thereby, the order dated 7/8/2025 in Mijji case number 161 of 2019 is stayed till the next date of listing. Scanned copies of the trial court records have already been received. Service report of notices to the respondent is awaited.
I'll take fresh steps, my lord.
Huh?
Fresh steps if necessary.
Full stop, fresh steps may be taken. This matter after 2 weeks.
My lordship, deeply over.
Hearing হতে নাই দেখোন। দিয়কচোন। মোৰ phone আহি আছে। Parties are not represented. A last opportunity is accorded to both the sides to place their submission, as this is an old pending case, full stop. On absence of any of the parties on the next date fixed, necessary orders may be passed. This matter after 1 week. After 1 week, not 2 weeks, DBA.
My lord, actually, this was
Oh, that's
listed
all.
at our instance, my lord.
Mm.
Other side appear also. Their name shown, my lord. Although that office note is not updated, but their name shown, my lord, they now cause this, my lord. They file a
We'll fix it for admission then.
Then, my lord, I have a small
You have
submission.
interim order also.
See, I have an interim order, but that interim order is, my lord, wrongly interpreted by the learned court below. What happened, my lord, here in this case, I'll give the background of the case. I am the decree holder. I got the suit was in my favor, and also there is some slight modification that file appeal also filed, decree was, my lord, we must my favor. Then I file an application for execution. In an execution, my lord, Nazir, my lord, going to give a possession, and then find that some other people are staying there. Not the judgment debtor, my lord, some other people. So, my lord, then I asked the deputy commissioner to give some protection, then we will be. Then in the meantime, my lord, those person, my lord, file an application before this honorable, before the final trial. That this is not binding on us. That application, my lord, we took a preliminary objection. That on limitation. So I request the learned trial execution court, the preliminary issue may be framed regarding point of limitation. So that was refused. Then I before this honorable court, and this honorable court stayed the execution proceeding, my lord. My execution is stayed. I have no objection, man. But the application filed by them, that is, my lord, continue. Under order 21 rule 97 petition is continuing, which is filed in the execution. Main case is in stay by this honorable court, but my lord, the miscase is in running, my lord. So that's why, my lord, your lordship kindly passed an order, fix it next week for the admission. And my lord, in the meantime, my lord, along with the execution, the application filed in the execution case also may be stayed, my lord.
How can I stay?
No,
There
my
is
lord,
another case, you have to come.
no, that is in the main case, my lord. That is in the not in title, so that is in the execution case, my lord. That application, Ms. J case, my lord, when
Nijay case is filed in the execution case.
in the execution case by
And
the,
you are before this court in the execution case.
yes, no, I am before this court, my lord, not framing the preliminary issue in the Ms. J case, Ms. case, my lord.
Execution case.
In execution case,
Same execution case.
same execution case. Your lordship kindly see page 11, my lord.
So,
Sorry, page
What
110,
do you
kindly,
want now?
my lord.
What do you
I
want
just,
now?
your last, I'll point it out.
That
110, page 110, you kindly.
going on there.
Yes, my lord. Your lordship kindly peruse my lord, 110 page,
110.
110. Page 110, my lord.
Hundred and ten.
Your lordship kindly see order sheet.
Hmm.
Ms. J case number 59 of 25 in connection with title execution case number 2 of 24. Now 2 of,
Arising out of that Ms. J case.
my lord. So 2 of 24 has been stayed by this honorable court, but they are continuing the 59, my lord. So that's why I am submitting, my lord. Your lordship, any that 59 also may be, my lord, stayed. Next day, my lord, for final disposal.
Okay, I stay 59. In connection with TX number, because it is arising from the title execution. case.
My lord. Otherwise, my lord, if your lordship, my purpose will be because
Misunderstanding,
My lord.
misunderstanding.
Yes.
So there, evidence and everything is recorded or
Only
it will be
objection.
heard, huh?
Only objection filed.
Only objection.
So till next date, my lord, your lordship.
Yeah, can be stayed. I
My
don't
lord.
know. Main case has been stayed, TX
Only this
number,
title execution stay.
but the other one is going on.
Other one in miscase and that title is not going on, my lord, cannot be, my lord, actually.
Learned, Hard Learned Senior Counsel Mr. T.J. Mohanta, assisted by Learned Counsel Ms. P. Bhattacharya, comma, for the petitioner, full stop. It is submitted that the title execution case number 2 of 2024 has been stayed by this court by order dated 26/9/2025. Okay.
My lord,
But an offshoot of the title execution case number
59 of 20.
2 of 2024 and registered as Ms. J case number 59/2025 under order 21 rule 97
97.
is continuing against the order passed by this court on, okay? I'll add like that. Against the order, which is against the order,
My lord,
which is against the order passed by this court on 26/9/2025 as the TX case number or as the Miss J case number and the 59/2025 is an offshoot of TX case number 2 of 2024, and this main case, i.e. TX2 of 2024 has already been stayed by this court. Full stop. The learned court below has misconstrued that the offshoot may continue.
my lord,
And learned court of civil judge. Civil judge
Civil Judge Senior Division.
Civil judge senior division is proceeding
no.
to civil judge senior division. Nagaon, Assam is proceeding to hear Miss J case number 59 of 2025, which will result in multiplicity of proceedings and will also have a bearing on the on this instant CRP on this instant civil revision petition. All right.
My lord. And then fixed for,
Considering the submissions at the bar, it appears that the Miss J case number 59 of 2025 under order 21 rule 97 CPC may be stayed at least till the next date of listing, and thereby Miss J case number 59/2025 is stayed till the next date of listing. Full stop. Service report on respondents is awaited. List this matter after 2 weeks.
yes, my lord, that may be fixed because only one point, my lord, this preliminary issue has to be framed. Only one point.
Date may be fixed. There is a detail, so.
My lord, no problem. My lord. Keep it up. Actually, my lord, with service report only in respect of 7 only, but because 1 to 6 they are appearing, my lord. Their name shows in the call list, my lord. All right, I'm not going for that. Anyway,
It will cause confusion. I won't add all this.
my lord,
Next
sorry,
day-
sorry,
next
sorry,
day
my
we
lord,
will
sorry, my
add.
lord.
Yes.
I was dependent in dispute matter that if trial court allow this dismiss the suit on the ground of limitation, and at appellate stage it was allowed, and against that disappellation
Suit was dismissed on the ground of limitation.
limitation
That main suit.
main suit, that is the
Title suit or money suit?
title suit. Declaration of right title interest.
Okay. On limitation, okay. Then what about the appeal? What happened to the appeal? First appeal?
First appeal, it was reversed, only
Okay.
it was, appeal was allowed.
You are the original plaintiff.
The dependent,
You are the original defendant.
dependent.
Okay. Both parties are ready with the hearing? Okay.
The plaintiffs purchased the land from Suren Das,
Mm.
and we were possessing the land
Mm.
at that time during Suren Das, and Suren Das legal years transferred the land during, while I was in possession. During my possession, it was transferred to the plaintiffs. The land was transferred to the plaintiffs.
Mm.
And their say is that on a date,
So you are the
5/9
legal heirs of Surendas.
plaintiffs,
Purchased the land from Surendas.
Suren Das legal years.
Oh, from legal heirs of Suren Das.
Yes.
How are you related?
We were in possession, Malade, since long back.
Oh, you were in possession.
Evidence is there. About 16, 17 years, we were in possession before passage of the land. And our stand is that we made agreement also and orally purchase also, but it could not be materialized through execution of the register of title. But we were in possession.
By oral agreement. You were in possession of the land by oral agreement.
But not in a, not with
Adverse
agreement.
possession.
Initially, yeah, our stand was in the suit that an agreement was made for purchase of the land, but sale deed was not executed. And that is why we were in possession all throughout during Surendra's life and after
So
that too.
there was an initial agreement according to you.
Yes,
So according to that initial agreement, you were in possession of the land.
yes.
That-
Since before the agreement, we were in possession.
Okay.
But the agreement was done for purchasing the land, but it was not purchased. But we were in possession during purchase of the land by the plaintiffs also. That is the case, and they have made out a case in favor of them that on 5/9/25 they were ousted from dispossessed from the land, and accordingly suit was filed for their right title interest, declaration of right title interest, and for possession.
Okay.
But if I read the judgment of the trial court first, my lord,
Yes, yes.
your lordship will find at page 19. I'm reading the judgment.
Yes, yes.
The plaintiff's case is that the land measuring 1 bigha 2 kotha 10 less as described in Schedule Kho is the suit land. Earlier, Surendra Das was the owner and possessor of the land. After his death, his legal heirs, Sudhanshu, Sukhdev, Sushil, and Biswadev inherited the said land. On 10/2/2005, the plaintiffs purchased the suit land from Sudhanshu Das and others by executing registered sale deed number 57 of 2005. On 5/9/2005, the defendants number 1 to 7 entered upon the suit land and constructed one thatched house and covered the suit land by fencing, thereby dispossessing the plaintiffs. The plaintiff number 2 filed a case under section 145, 146 CRPC, and the suit land was attached. Upon objection by the defendant, the attachment was vacated. The case was transferred to Tamulpur and was numbered as 4M10. The defendant number 1 and 2 have claimed the suit land to be their property, hence this case. Defendant contested the suit and submitted written statement submitting inter alia that there is no cause of action, that the suit is barred by limitation, and that suit is not maintainable. The defendant stated that Surendra Das was the original owner of the suit land, but during his lifetime, the defendants had purchased the suit land about 28-30 years ago from the original owner Suren Das. Defendant number 1 had taken possession of the land and has been residing upon the suit land since 28 to 30 years peacefully. The sale deed number 5705 is illegal, and the defendant has already acquired right title and interest over the suit land by way of adverse possession. Upon the pleadings of the parties by my predecessors in office framed the following issues in this suit: whether there is cause of action of the suit, whether the suit is barred by limitation, whether the defendant number 1 to 4 acquired right title interest, over the suit land by way of adverse possession, whether the plaintiffs are entitled to decree as paid for, to what other relief or reliefs the parties are entitled to. Besides exhibiting documents, the parties adduced oral evidences in support of their pleadings. Heard arguments of the learned counsel for the plaintiffs and the defendant, and my findings on the points are narrated below. Discussion on evidence, decision, and reasons thereof. Issue number 1, whether there is cause of action of the suit. Cause of action is a bundle of facts which, taken with the law applicable to them, gives the plaintiffs a right to relief against the defendant. It consists of every fact which is necessary to be proved to entitle the plaintiff to a decree. Here the plaintiff has stated in the plaint that the defendants have illegally occupied the suit premises and have dispossessed them. They have purchased the suit land by a registered sale deed. The defendant denied the allegation and stated that the suit premises belong to them and that they have acquired right, title, and interest over the suit land by way of adverse possession. The plaintiffs are to prove the existence of facts upon which they have based their claim. Therefore, it appears that there is cause of action for the suit. The suit is, whether the suit is barred by limitation. The defendant stated in the written statement that the suit is barred by limitation, but they have not stated clearly as to how the suit is barred. According to the plaintiff, they purchased the suit land on 10/2/2005, and the defendants have dispossessed them from 5/9/2005. The plaintiff had filed under case under section 145, 146 CRPC. Later on, the case was transferred to Tamulpur and numbered as 4M/10. Thereafter, the plaintiff filed this suit in the year 2013 and for declaration of possession, partition, possession, and other consequential relief. Considering the facts, I am of the opinion the suit is not barred by limitation. Issue number 3, 4, and 5, whether the defendant number 1 to 4
But
required.
you submitted no, on limitation it was dismissed.
No, dismiss on other, here it is stated that it is not
Barred by
barred by
limitation.
limitation, but in subsequent.
Okay, all right.
Paragraph 9, for the sake of convenience, these issues are taken up together. The plaintiffs have stated in their plaint that land measuring 1 bigha 2 10 lessons described in Schedule 4 is the suit land. Earlier, Surendra Das was the owner and possessor of the land. After his death, his legal heirs, Sudhanshu, Sukhdev, Sushil, and Vishwadev inherited the said land. On 10/2/2005, the plaintiffs purchased the suit land from Sudhanshu Das and others by executing registered sale deed number 57 of 2005. On 5/9/2005, the defendants number 1 to 7 entered upon the suit land and constructed one thatched house and covered the suit land by fencing, thereby dispossessing the plaintiffs. The plaintiff number 2 filed a case under section 155, 156 CRPC.
Just a moment, you see, this case will take some time. We can reassemble in the afternoon. This case will take some time. Yes,
Yes.
it will take some time. Hearing, and then maybe I'll pass an order also. So then we can reassemble in the afternoon. We'll take up your matters in the afternoon. And this, if this is not over by afternoon, then I'll continue tomorrow. But this case will take some time,
Yes,
okay?
yes.
Okay. We can reassemble in the afternoon. You all can come in the afternoon. If this doesn't get completed by first half, then I will take up your matters in the afternoon and we'll continue till tomorrow. This will take some time. This is an RSA relating to 1 big half land. It will take
Yes.
some time. Afternoon, after 2,
Yes.
I'll take up the other matters. You can continue. Others, I'm saying others.
Yes.
Others of course. Because what is the point of sitting? You can attend the other courts also. You can place your submission. See, no point of sitting and waiting. This will take some time. This is an RSA relating to 1 big half land. Afternoon. We'll continue in afternoon, you see. That is why, because of personal freedom. Because of personal freedom, we'll take up in the afternoon.
It would be a bit tiny fix.
And this we will continue tomorrow if it doesn't get over by today afternoon, today, first start. I'll take up. Yes, we'll take up at 2. Yes.
Then. Defendants, on the other hand, stated that Surendra was the original owner of the Sugar.
My lord, there is just one thing. Apologies, my lord, for the interruption, my lord. In respect to item number 13, my lord, it was called before the orders was completed. I was in the court. Apologies, my lord, I was.
I'm in midway I'm hearing a matter, serious matter.
My lord, I'll make a mention at two.
After how, you can wait till 2, where is the problem?
My lord,
You want to go home before 2?
no, mas. Much.
Please wait till 2.
Mal.
Yes.
That the defendant, on the other hand, started that Surendra Das was the original owner of the Suitland. But during his lifetime, the defendants had purchased the Suitland about 28 to 30 years ago from the original owner, Surendra Das. Defendant number 1 had taken possession of the land and has been residing upon the Suitland since 28 to 30 years peacefully. The sale deed number 57 of 2005 is illegal and the defendant has already acquired right title interest over the Suitland by way of adverse possession. In support of their claim, plaintiff adduced evidence of 4 witnesses. PW1 Subhas Das stated that they had purchased the Suitland by executing registered sale deed number 57 of 2005. He exhibited the sale deed as Exhibit 3 and stated that the deed was written by Bharat Nazari and then Nonikanto Das was the attesting witness. Other PWs have also admitted the execution of the sale deed, but the plaintiffs failed to duly prove the execution of the sale deed by adducing the attesting witnesses. PW1 stated that the defendants are in possession of the Suitland after required. PW2 Sukhdev Das stated during his cross-examination that he has only heard that the defendants have dispossessed the plaintiffs. He has not seen them while dispossessing. PW3 Ranjit Sutradhar stated during his cross-examination that the defendants are in possession of the Suitland since 2005 and that Subhas and others were in possession for 3-4 years. However, he admitted that the defendants are in possession of the Suitland. PW4 Krishnasaran Das stated during his cross-examination that the defendants are in possession of the Suitland. He admitted that he had stated before the court in a previous suit that the defendants are in possession of the Suitland since 17-18 years. He also admitted that he has only heard that the defendants have dispossessed the plaintiffs. He has not seen it. The defendants had adduced evidence of 4 witnesses in support of their claim. The DW1 Amulya Das admitted that he has not filed any case for cancellation of sale deed. He stated that he has heard about the sale deed, but he has not seen it. He stated that he had purchased the land in the year 1983 verbally. DW2 Thoni Das stated that the defendants had their States House before the plaintiff filed a case under section 145. However, DW3 and DW4 stated they do not know much about the Suitland. From the above discussion, it appears that the plaintiffs have admitted that the defendants are in possession of the Suitland from 17-18 years. PWs have admitted that the defendants are still in possession of the Suitland since 2005 also. Although plaintiffs have claimed that they were dispossessed by the defendants on 5/9/2005, but they could not substantiate their claim by adducing proper evidence. PW2 and PW4 have stated clearly they have only heard about disposition. They have not seen any incident as alleged in the plaint. The plaintiffs have claimed right title interest over the Suitland and filed this case on the basis of a sale deed. Although the plaintiffs have stated that they have purchased the Suitland from the legal heirs of Surendra Das by executing a registered sale deed, but the execution has not been duly proved and established by the adducing proper evidence. None of the attesting witnesses or writer of the deed were examined in evidence. On the other hand, the defendants have pleaded that they have acquired right title interest over the Suitland by way of adverse possession as they have been possessing the Suitland peacefully since 28 to 30 years to the knowledge of the original owner and without any resistance from the original owner and any other person. The plaintiff's witnesses have also admitted their possession since 17-18 years. Hence, the plaintiff failed to establish their claim. Accordingly, suit is dismissed on with contest.
Okay.
So now reversal of the findings of the trial court, how it is made and how it is forward, that may be looked into by the summary suit. At page 6, the
Okay.
civil courts, civil judge Nalbari judgment.
Mm.
Judgment is from page 7.
Okay.
I need to read the facts only
Mm.
the from the issues, my lord, the issue
Mm.
number 1, I am
Okay.
reading at page 11. Issue number 1, whether the cause of action of the suit. In this suit, the plaintiffs have claimed that they purchased the scheduled land on 10/2/2005 from the legal heirs of original owner, late Sudhanshu Das, filed registered sale deed and put in possession. On 5/9/2005, the defendants disposed of the plaintiffs, whereas the defendants have claimed that the defendant number 1 had purchased the suit land from late Surendra Das by an oral agreement, and he has been in possession over it since 28 to 30 years by constructing house thereon. The plaintiffs claim that the defendant have peacefully entered the suit land and constructed a thatched house and put fencing around the suit land. Considering the claim made by both the parties over the suit land, I found that there is cause of action for the suit. Issue number 2, whether the suit is barred by limitation, and the issue number 3, whether the defendant number 1 to 4 acquired right title interest over the suit land by way of adverse possession. The defendants in their written statement had raised a plea that the suit is barred by limitation, but the defendant in their evidence did not specifically mention the ground for which the suit is barred by limitation. It is perverse because grounds that has been stated that they are also during purchase and before purchase they were in possession of the land. So this portion is perverse. The plaintiffs claim that they purchased the suit land from the legal heirs of Surendra Das on 10/2/2005, and on 5/9/2005 at 8 p.m. the defendant disposes the plaintiff and constructed a thatched house and boundary fencing. This suit was filed on 28/5/2013. Therefore, the suit is found to have been filed within the period of limitation. The defendants have claimed that the defendant number 1 had already purchased the suit land from Surendra Das about 30 years ago, and since then he has been possessing the suit land continuously by constructing the house thereon and adverse to its owner. As the defendants have claimed that they are in possession over the suit land in adverse to its original owner, therefore the burden is on the defendants to prove their plea. The defendants number 1 deposed DW1 and stated that Surendra Das sold the suit land to him orally about 30 years ago by taking necessary consideration. He took possession of the land and has been staying on the suit land and with his family by constructing house thereon. He further stated that the defendants have been possessing the suit land for 30 years adversely and hostile to the original owner, and therefore they had acquired right over the suit land. During cross-examination, DW1 stated that he purchased the land in the year 1983 and he doesn't have any document. He also stated that he doesn't have houses on the four boundaries of the suit land. Surendra Das died in the year 1985-86. He has not made the legal heirs of Surendra Das or the neighboring persons of the suit land as witnesses in this suit. He did not submit the revenue paying receipt. DW2 is the son of defendant number 1. And my lord, the revenue paying receipt, if I produce, my lord, myself, then where is the question of claiming adverse possession?
But can you claim adverse possession by saying that you have purchased the land?
My lord,
You must not be the owner, then only you can claim adverse possession.
I was not owner.
So, but
I-
you have stated that
my-
you are the owner.
Yes, my initial claim was that I already purchased,
Hmm.
but it was not materialized through by registering a sale deed. But I also, that period, my lord, I was possessing, and I was in possession during their purchase also, during the time of their legal years. And during my possession, my lord, the land was sold, my lord. So he did not submit the revenue paying receipts. Only I have pointed out this because the basis of finding of the appellate court revenue paying receipt, that according to the court, my lord, it is the main criteria for showing the possession of the person concerned. Revenue paying receipt. He did not submit the revenue paying receipts. DW2 is the son of the defendant number 1, and he also stated that they have been possessing the suit land by construction of the house, and on the basis of it for last 30 years. They have land on the eastern side of the suit land. He cannot say about the measurement of the land and have on the eastern side of the suit land. DW3 and DW4 are the independent witnesses who, in their evidence in chief, stated they saw the defendant cultivating the suit land for last 30 years. So these are the evidences. These evidences were ignored during passing these judgments. Defendants cultivating in the suit land for last 25 to 30 years. DW4 also confirmed that the defendant number 1 has got land on the east of the suit land. From the evidence in chief and cross-examination of the defendant's witnesses, I found that there is a major contradictions regarding the nature of the suit land and the way it is being possessed by the defendants. DW1 and DW2 stated that they are possessing the suit land for 30 years by constructing house and basti land thereon. Whereas DW3 and DW3 contradicted that above the above nature of possession by stating they saw the defendants possessing the suit land by cultivating on it. Only since they did not state that regarding house, my lord, only that part of contradiction has been taken into consideration. But here it is a case for declaration of right title interest, and a declaration of right title interest that if should be decreed, my lord, is required to be decreed, that should be on the basis of the plaintiff's own case, my lord, not because of the some lacuna of the defendant's evidences. The DW1 and DW2 admitted that they have land on the east of the suit land, but DW1 has stated that Nogenda's house on the land east to the said land. The fact creates doubt as because if DW1 has land on the east of the suit land, then how Nogen can have the house on the east of the suit land? The defendant's witnesses did not say if there is any zerat planted by the defendants in the last 30 years. The defendants did not adduce evidence of neighbors to prove their continuous possession over the suit land. This portion is also perverse because already there is finding of the trial court that DW2 and 4 clearly stated regarding their possession. Even last 17, 18 years possession that has been stated by the witnesses. The defendants did not produce any revenue paying receipts or any other documents to prove their possession over the suit land. Revenue paying receipts doesn't say about regarding possession, etc. So this finding is illegal. Therefore, it is not believable that the defendants were in possessing the suit land since 30 years. On the other hand, the defendants have taken two plea over the suit land. The defendant stated that the defendant number orally purchased the suit land from Surendra Das about 30 years ago. But they did not insist Surendra Das or after his death, the legal heirs of Surendra Das to register the sale deed. The defendants never stated about the consideration amount they paid to Surendra Das or for orally purchasing the suit land. There cannot be valid sale orally if the value of the land, it is not our case. My lord. Our case is that the suit is barred by limitation because of our long position. Issue number 4, the plaintiff pleaded that they purchased the suit land from the legal heirs of Surendra Das on 10/2/2005 and on 5/9/2005 at 8 p.m. The defendant disposes the plaintiff and constructed a thatched house and boundary fencing. To prove the pleadings, the plaintiff adduced evidence of 4 witnesses. The plaintiff Subhash Das deposed as PW1 and he stated that he and the other plaintiffs purchased the suit land from the legal heirs of original owner Surendra Das by a registered sale deed 57 of 2005 and dated 10/2/2005. He furnished the original sale deed and marked as Exhibit 3 and he has exhibited the signatures of the vendors, writer and attesting witnesses. Attesting witnesses' signature, the finding of the trial court was different, my lord. They failed to
Produce the witnesses and examine them.
yes. He stated that after purchase of the suit land, the plaintiffs were put in possession of it on 5/9/2005 at about 8 p.m. The defendants disposed them from constructing thatched house and fencing. PW2 Sri Sukhdev Das corroborated the evidence of PW1 by stating that he and his brothers have executed the sale deed and possession over the land was handed over to the plaintiffs. He confirmed the execution of the registered sale deed by stating that Exhibit 3, 6 to 10 is his signatures. He has also identified the thumb impression of their brother Sudhanshu Das, signature of his brothers Vishwadev and Sushil Das. The plaintiff has been able to prove the execution of registered sale deed by adducing evidence of one of the vendor. Since vendor has admitted the execution of the sale deed, there is no need of proving the same by adducing evidence of writer or attesting witnesses of the deed. Learned court below made the error by holding that the plaintiff failed to prove the execution of the sale deed, as the plaintiffs did not examine the writer or attesting witnesses of the execution of the sale deed. As regards possession of the suit lands, PW1, PW2, PW3 categorically stated that plaintiffs purchased the suit land and they were put in possession over the suit land on 5/9/2005. Defendants disposes the plaintiffs. This portion is not in the evidence, that they were put in possession of on 5/9/2005. During cross-examination of PW1, PW2, and PW3, the defendants could not bring out any fact to show that the defendants were possessing the suit land for last 30 years by constructing the house. This portion of the findings is perverse to the evidences on record. The PW3 during cross-examination stated that there is no house of the defendants in the suit land and it is an agricultural land. The defendants are now possessing it. The learned court below considered the statement made by the PW4 during cross-examination that he had disposed on behalf of the plaintiff in another case where he stated that the defendants were in possession over the suit land for last 17 to 18 years. And on the basis the learned court below had hold that the plaintiffs failed to prove that they were possessed by the defendants in the year 2005. They were dispossessed by the defendant in the year 2005. In fact, dispossession could not be established through any witnesses. I found that learned court below relied upon the said statement of PW4 without verifying the same with any record. Even the case number or the nature of the case is not known. If the statement of PW4 was to be relied upon, it should have been proved that the defendants, by calling record of the case of where PW4 gave such evidence. I found that the learned court below did not consider other evidences available to decide the issue. I found that the plaintiff have been able to prove that they have purchased the suit land by a valid registered deed. And it is found that the defendants have failed to prove that they had already purchased the suit land from Surendra Das about 30 years ago. The defendants have also failed to prove that they have been possessing the suit land for last 30 years. So this is perverse, the evidence in the report. Because it is clearly the DWs, the evidences of DWs have stated, and that the evidences could not be dismantled regarding continuous possession of last 17 to 18 years. And even prior to that, since the lifetime of Surendra Das, the defendant has been possessing the suit land. So this portion of the findings of the appellate court is perverse. And on the basis of that, my lord, my humble submission before this honorable court, if your lordship sees the evidences, my lord, then it would be clear.
Come back after 5 minutes.
Yes.
Evidence. Evidence.
Only clause part,
Okay.
PW4. Cross examination.
Okay.
PW4,
Mm.
Krishna
PW4, no?
Yes.
What is his name?
Krishna Sarandas.
Yes. PW4, yes.
Last,
Krishna Sarandas, yes.
last portion.
Mm.
পূবে অমূল্যৰ কিমান মাটি আছে নাজানো আগেও কেছ এটা হৈছিল মই সেই কেছত বাদী হৈ সাক্ষী দিছো তাত কৈছো যে বিবাদী 17-18 বছৰ দখল কৰি আছে তাত ঘৰ বস্তি আছে এতিয়াও বিবাদীয়ে ঘৰ বস্তি কৰি আছে জিৰাত নাই খেতিৰ মাটি নেক্সট মানে suggestion given by the plaintiff to DW2, DW2 Omulya Das.
Okay, yes, Omulya Das.
Das.
Mm.
Last portion of evidence.
Mm.
সত্য নহয়
Yes, সত্য নহয়।
সত্য নহয় সুনীল আৰু সুভাষে প্ৰদৰ্শক 3 যোগে মূল পাত্তাদাৰৰ পৰা 10-2-2005 কিনি ৰেজিষ্টাৰ কৰি লৈছে আৰু
অমূল্য দাস
অমূল্য দাস
সত্য নহয় সুনীল আৰু সুভাষে
সত্য নহয় সুনীল আৰু সুভাষে প্ৰদৰ্শক 3 যোগে মূল পাত্তাদাৰৰ পৰা 10-2-2005 কিনি ৰেজিষ্টাৰ কৰি লৈছে আৰু দখল সমজি লৈ ভোগ দখল কৰি আছে
I couldn't find.
So, Malad, the suggestion is
I cannot find, no. সত্য নহয় সুনীল and সুভাষে
that it
It
is
is অমূল্য দাস, no?
Omulya Das. DW2.
DW
2.
2, yes,
The
but
first-
I cannot find.
A third page. Page number 3.
Third page, I have checked the entire. I'll just see. Just a moment. I'll read it and I'll find out. Now I got.
সত্য নহয়
Mm.
সুনীল আৰু সুভাষে প্ৰদৰ্শক 3 যোগে মূল পাত্তাদাৰৰ পৰা 10-2-2005 কিনি ৰেজিষ্টাৰ কৰি লৈছে আৰু দখল সমজি লৈ ভোগ দখল কৰি আছে that means
Mm.
Malad, registered sale deed was executed on 10/2/2005 and on that day only they got possession and they have been possessing. So this is their suggestion And on the other hand, the evidence is of the already I have shown in cross part, and even in our the evidence is used by us that has not been controverted regarding continuous position. And এই কেছত বাদীৰ হৈ সাক্ষী দিছো তাত কৈছো যে বাদীৰ 17-18 বছৰ দখল কৰি আছে বুলি তাত ঘৰ বস্তি আছে
What are you reading? Whose evidence?
the PW4 already I have shown
Yes, yes.
the even Phonidas cross part of the Phonidas the defendant in this case DW2 in
Omulya is DW2, no?
DW2 Phonidas DW2 even Phonidas also the number has been given DW2
Oni is also DW2.
wrong it may be DW3
It's okay. It's okay. We'll keep the numbers.
Phonidas will be DW1 the omission is Phonidas son of Omulya Das অমূল্য আৰু সুনীল হতৰ মাজত নালি চলে বহুত বছৰ ধৰি কেছ চলি আছে 1 বিঘা 2 কঠা 10 পেচা মাটিৰ পৰিমাণ আগতে মাটি সুৰেনৰ আছিল সুৰেনৰ ল'ৰা সুধাংশু সুদেৱ সুশীল আৰু বিষ্ণুদেৱ সুৰেন মৰাত এওঁলোক মালিক হয় যদিও নাজানো বাদীয়ে এই মাটি যদি 10/2/2005 কিনি লৈছে নাজানো তাত আমাৰ আগৰে খেৰিঘৰ আছে তেওঁলোকে 145 জাগা কেছ কৰিছে সত্য নহয় যে ঘৰ বনোৱাৰ পিছত 145 জাগা কেছ কৰিছে মাটিটো পুলিচে জব্দ কৰে পিছত তামুলপুৰত কেছটো চলি আছে কেছটো যদি উঠাই লৈছে নাজানো আমাৰ মাটি কিনা দলিল কাগজ নাই সুৰেন দাস মৰাত 30 বছৰৰ বেছি হ'ল তেতিয়া মই 14-15 বছৰীয়া বাদীৰ লগত so this is the cross part but there is no contradiction regarding the evidences produced by the DW1 ইয়াৰ সাজেশনে যে সত্য নহয় আমি মাটিটো বলপূৰ্বক 5/9/2005 চনত দখল কৰোঁ so my humble submission before this honorable court that already evidences are there that we have been possessing continuously since 30 years before and evidences are there that last 17-18 years continuous possession is there while they purchase the land so the appellate court's finding so far possession and disposition in regarding disposition also there is no evidence at all that on 9/5/2005 they were dispossessed there is no evidence at all the finding of the trial court that has not been reversed by the appellate court also so the finding of the appellate court regarding their getting possession is perverse and to the evidences and records so the suit is liable to be dismissed this is my humble submission with it.
Basically, your lordship. My lord, in this case, though they said that they made agreement before purchasing the land orally, that agreement statement was not mentioned in the WSA, your lordship. At page 36, paragraph 5. wherein they never stated that they made agreement with the original owner before purchasing the suit land.
So where did they say in argument
No, in
about
WS.
agreement? In WS, they have not stated.
In WS, they have not stated.
Then
Now
where did
they,
they say?
now they. place
In
this
evidence?
plea, yes.
In evidence you have
In,
seen?
no, evidence is not there.
Hmm.
But in there, today I heard that
Hmm.
they mentioned that they
Oh,
made agreement.
In appeal.
In appeal, that they before purchasing the land orally, they made agreement. And that agreement is not exhibited.
No, oral agreement. Oral agreement.
Oral agreement, that oral agreement, yes. And my lord,
Hmm.
they have already read appellate court judgment, which has been rightly passed the judgment. At page 11, issue number 2, which is important issue, your lordship,
Hmm.
wherein they, may I read your lordship?
Yes, yes.
The defendants in their written statement had raised a plea that the suit is barred by limitation, but the defendant in their evidence did not specifically mention the ground for which the suit is barred by limitation. The plaintiffs claimed that they purchased the suit land from the legal heirs of surrenderers on 10/2/05 and on Iman 5/9/2005. The defendants dispossessed the plaintiff and constructed a thatched house and boundary fencing. The suit was filed on 28/5/13. Therefore, the suit is found to have been filed within the period of limitation.
You tell me, how can it be within the period of limitation?
Lordship.
It is 10/2/2005.
Lordship.
The plaintiffs claim that they have purchased the land
And from the,
10/2/2005, and on 5/9/2005 at 8 p.m. the defendants dispossessed the plaintiff
Lordship.
and constructed a when the suit is filed after 8 years, how can
Lordship,
they should be within period of
I'm
limitation?
coming to that, your lordship. Immediately, they have filed a case under section 145 CRPC, which has been registered as 205M05. Immediately, they have filed a case. And thereafter, that case has been transferred to Tamulpur, which has
Just
been
a
registered,
moment,
lordship, at page 8. And in plaint also, we described. Plaint case to this one. Okay.
Immediately you filed a 145 case.
Lordship, page 32, my plaint, your lordship, may kindly see at para 4, page 32. That due to the sale illegal activities of the defendants, the plaintiffs on apprehension of breach of peace of public at large had to institute proceeding under section 145(1)46 of the Code of Criminal Procedure. Procedure, and on being satisfied with the facts and circumstances of the case, the court passed an order for attachment of the said land, and accordingly the police attached the land. But subsequently, on the objection of the defendants, the said attachment order was vacated. Further, the case was transferred to the Tamulpur, and the subdivisional officer civil registered the said case as 4M of 2010. That case was continuing, that the defendant number 1 and 2 entered appearance in the said criminal proceeding and submitted their written statement, and they falsely claimed that thereby they purchased the said land. The plaintiffs felt that they may not get proper reliefs in the said proceedings, and in an impelling situation has instituted this suit. The criminal proceeding being 4M 2010 was dropped, since being withdrawn the plaintiffs. That case has been withdrawn. Thereafter, the suit is filed. Thank you, sir.
All right. Then we'll go back again to issue number 2.
Issue number, yes, sir.
Page
At
just
page 11.
One minute, page 11.
11, your lordship. Bottom portion.
Page 11, yes.
Lordship. The defendants have claimed that the defendant number 1 had orally purchased the suit land from Surendra Das about 30 years ago, and since then he has been possessing the suit land continuously by constructing the house thereon and adversely to each owner. As the defendants have claimed that they are in possession of the suit land in adverse to its legal owner, therefore the burden is on the defendants to prove the case. The defendants 1 deposed DW1 and he stated Surendra Das sold the suit land to him orally about 30 years ago by taking necessary consideration. He took possession of the land and has been staying on the suit land with his family by constructing house thereon. If, my lord, they have constructed the house over the suit land since 30 years, so they at least they have exhibited one electricity bill, one revenue receipt, something, one piece of document they have to produce, but nothing. Simply saying that we have built house, we staying thereon, and we have purchased the land orally. Even they have not filed any case for cancellation of our sale deed if it is illegal, as per their version. They have not done took any legal remedy for cancellation of my sale deed, Lordship. He further stated that the defendants have been possessing the suit land for last 30 years adversely and hostile to the original owner. Therefore, they had acquired right over the suit land. During cross-examination, DW1 stated that he purchased the land in the year 1983 and don't have any document. He also stated that he don't have houses on the 4 boundaries of the suit land. Surendra Das died in the year 85-86. He has not made the legal heirs of Surendra
So
Das.
you see, once he is saying that he has house
Lordship,
over the suit land, and
If-
again in cross-examination, he is saying that he does not have
any house,
house
contradicted. He,
within the 4
he-
boundaries of the suit land.
After examination, he has stated, DW1, that he has house. In
no, it is
DW1.
mentioned.
in cross part, there is
Lord-
Let's
Lordship.
see, DW1,
DW1.
let's see the.
Only-
cross-examination.
Condition road.
Only does.
Honidas, no?
Yes.
Lordship.
DW4, DW1, DW2. Here he is stated as DW1. Where he is stated?
তাত আমাৰ আগৰে পৰা খেৰী ঘৰ আছে। তেওঁলোকে 145 ধাৰা
তাত আমাৰ আগৰে পৰা খেৰী ঘৰ আছে।
আছে। In cross part, he has stated.
So this has been wrongly. Let us read the cross-examination of Honidas. Please read. Anybody?
No, dear, it is so. নেকি? অমূল্য আৰু সুনীলহঁতৰ মাজত নালিচা লৈ বহু বছৰ ধৰি কেছ চলি আছে। 1 বিঘা 2 কঠা 10 লেচা মাটিৰ পৰিমাণ। আগতে মাটি সুৰেনৰ আছিল, সুৰেনৰ ল'ৰা সুখদেৱ,
Sudhanshu, I think.
সুধাংশু, সুখদেৱ, সুশীল এণ্ড বিশ্বদেৱ। সুৰেন মৰাত এওঁলোকে মালিক হয় যদি নাজানো। 05ত কিনি লৈছে নাজানো। তাত আমাৰ আগৰে খেৰী ঘৰ আছে, তেওঁলোকে 145 ধাৰাৰ কেছ কৰিছে, সত্য নহয়। ঘৰ বনোৱাৰ পিছত 145 ধাৰাৰ কেছ কৰিছে, মাটি লৈ পুলিচে জব্দ কৰিছে, পিছত তামোলপুৰত কেছটো চলি থাকে, কেছটো যদি উঠাই লৈছে নাজানো। আমাৰ মাটি কিনা দলিল কাগজ নাই, সুৰেন মৰা 30 বছৰৰ বেছি হ'ল, তেতিয়া মই 14-15 বছৰীয়া। বাদীৰ লগত অন্য কেছ নাই, দাগ নং পাতা নং জানো।
So now here, just a moment, in this judgment, Honidas is the father or son?
Son,
Son.
Honidas is the son, no?
He
Son of Omulya Das.
he was
No, but
14 years.
this DW1 is then Omillo Das. Honidas is DW2.
Yes, sir. Maybe, but yeah, here rightly written, wrongly written. That is,
Let's see, Amulya Das. Mulya Das. No, that this judge has written that DW2 is the son of DW1.
Oh, wrong.
So he will be Amulya Das only. So let us read Amulya Das.
Amulya Das did.
Let us read what Amulya Das has stated.
Yes.
Maybe he has stated that he does not have a house.
DW2 বুলি কোৱা আছে, কিন্তু
No, this is DW1 only. Amulya Das is DW1, correctly written by the
Yeah.
judge.
So the certified copy is wrongly.
Yeah, maybe, because handwriting is little bit difficult.
I'm reading on course party. Your Lordship.
DW1, yes, Amulya Das,
Lordship.
yes.
বিবাদী মাটি 1 বিঘা 2 কঠা 10 লেচা মাটিৰ মালিক সুৰেন দাস আছিল তেওঁৰ ল'ৰা সুধাংশু দাস সুখদেৱ দাস সুনীল দাস এণ্ড বিশ্বদেৱ দাস সুনীল সুভাষ ভাই ককাৰ সুনীল আৰু সুভাষৰ তাত 10/2/05 সুধাংশু সুখদেৱ সুশীল আৰু বিশ্বই বিক্ৰী কৰা বুলি নাজানো 2005 চনত এই মাটিলৈ বিবাদ হৈছিল তেতিয়া সুনীল আৰু সুভাষে 145 ধাৰাত কেছ কৰিছে তেতিয়া তেওঁলোকে কেছত তেওঁলোকে কি কৈছিল নাজানো মই দলিল দেখা নাই সিহঁতে মাটি কিনা বুলি ক'ব পাৰে মই নাজানো মই এই নামজাৰি কেনসেল কৰাইছো মই দলিলখন কেনসেল কৰিবৰ বাবে কেছ কৰা নাই মই সুৰেন দাসৰ পৰা 1983 মাটি কিনিছো কিনা কাগজ পত্ৰ নাই দলিল কৰা নাই কেছ লগা মাটিটোৱে মোৰ ঘৰ তাৰ উত্তৰে মোৰ ঘৰ নাই পূবফালে মোৰ ঘৰ আছে সৰি পূবফালে ঘৰ আছে নগেনৰ মাটিৰ চাৰিসীমাত মোৰ ঘৰ নাই সত্য নহয়
Correct. He has stated Mati Sarihima Mughornai. So DW1 has stated in evidence in chief that he does not,
But
he
his
has
son-
house.
His son has stated that Kheri Ghor আছে.
Son, he
he
14
was
years
at
old.
13
And Mati was taken 17 years back. Sons, no. He stated no, Mati
But
Sarihima
possession,
Mughornai.
so far possession is concerned, my lord, they were in possession, it is clear evidence. And
You see that
regarding
it is
the-
correctly written, Mati Sarihima Mughornai.
Ghor,
Lordship.
maybe, my lord, emphasis has been
So
given.
he has DW1, who is the defendant, main defendant. He has stated that he does not have a house.
But Kheti Mati বুলি,
Kheti, yes, Kheti is
Kheti-
there.
this is
He has been
cultivable
cultivating
land.
it, yes. But he does not have a house.
doesn't have house.
Cultivating it, yes.
letter person I have to
Yes, yes. No, no, not required. You can read, you can discuss your issue number 2.
Only here in this case, my lord, regarding disposition, there is no evidence. This is.
Let's see,
Yes.
let's see, yes.
for disposition we have to file a case 145 under section 146 your lordship Shall we see. During cross-examination DW1 stated that he purchased the land in the year in 1983 and he don't have any document. He also stated that he don't have houses on the four boundaries of the suit land. Surendra Das died in the year 1985-86. He has not made the legal heirs of Surendra Das or the neighboring persons of the suit land as witness in the suit. He did not submit any revenue paying receipt. DW2 is the son of defendant number 1 and he also stated that they have been possessing the suit land by construction house and bosti on it for last 30 years. They have land on the eastern side of the suit land. He cannot say about the measurement of land that they have on the eastern side of the suit land. DW3 and 4 are the independent witnesses who in their evidence in chief stated that they saw defendants cultivating in the suit land for last 25 to 30 years. DW4 also confirmed that the defendant number 1 has got the land on the east side of the suit land. From evidence in chief and cross-examination of defendant's witness, I found that there is a major contradiction regarding the nature of the suit land and the way it is being possessed by the defendants. DW1 and DW2 stated that they are possessing the suit land for last 30 years by constructing house and bosti thereon. Whereas the DW3 and 4 contradicted the above nature of possession by stating that they saw the defendants possessing the suit land by cultivating thereon. DW 1 and 2 admitted that they have land on the east side of the Suitland, but DW 1 has stated that Nogan has house on the land east to their Suitland. This fact creates doubt as because if the DW 1 has land on the east of the Suitland, then how Nogan can have house on the east side of the Suitland? The defendant witness did not say if there is any zirat planted by the defendants in the last 30 years. The defendants did not adduce any evidence of neighbors to prove their continuous possession over the Suitland by construction houses thereon. The defendants did not produce any revenue paying receipt or any other document to prove their possession over the scheduled Suitland. Therefore, it is not believable the defendants were possessing the Suitland since 30 years. On the other hand, defendants have taken two plea over the Suitland. The defendant stated that defendant number 1 orally purchased the Suitland from Surendra Das about 30 years ago, but they did not insist Surendra Das to register the sale deed. The defendants have never stated about the consideration amount they paid to Surendra Das for orally purchasing the Suitland. There cannot be valid sale orally if the value of the land is more than ₹100 for valid sale. That matter is specifically stated in the Registration Act, Your Lordship.
It's okay, yes, it has to be. Section 17 of the registration.
Lordship. That ought to be registered, that would be valid. From the above discussion, I found that defendants have failed to prove that they are in adverse possession over the Suitland since the last 30 years. So, my lord, they ought to
See,
exhibit.
I am telling that you must take only one plea. If you are purchasing, then you are purchasing the Suitland and occupying the land on purchase. But if you are on adverse possession, then you must take a plea of only adverse possession.
Adverse
You
possession.
cannot take two
It
pleas.
is
So-
correct, but orally purchased, that is the statement in the written statement. And thereafter, sale deed was not executed, but continuous possession is,
But
written statement is
our respondent is saying that it is not mentioned in detail.
mentioned in at page
Okay.
36 of the memo, we will, you will find paragraph 5. I am reading that.
Okay, not required, I'll read it.
Even regarding disposition, what I have submitted, that is from their own suggestion, it is clear. Already I have shown before your lordship, সত্য নহয় সুনীল আৰু সুভাষে প্ৰদৰ্শক তিনি যোগে মূল পাটাদাৰৰ পৰা 10/2/2005 কিনি ৰেজিষ্টাৰ কৰি লৈছে আৰু দখল সমজি লৈ দখল ভোগ কৰি আছে. If they are enjoying the land, then where is the question of disposition? Disposition has not been put by their own suggestion itself. There is no disposition at all. And disposition, if there is no disposition, then we are
Suggestion to
suggestion that is in respect of,
Omulya, no?
yes, Omulya.
Who is Sunil and Subhas?
Sunil and Subhas, your defendant. Sunil and Subhas are my lord respondent.
Sunil and Subhas, who executed the sale deed?
No,
Surendra's son,
no. Sunil Das, Subhas Das, the respondent.
sorry.
They have purchased the land from
Sunil and
Suraj.
Subhas, yes. The plaintiffs, their own suggestion says that they are enjoying the land. If enjoying the land, then where is the question of disposition? So this, their suggestion,
What you're saying? DW2 or DW1?
DW1
Omulya.
Omulya Das.
সত্য নহয় সুনীল আৰু সুভাষে পদকক তিনি যোগে মূল পাটাদাৰৰ পৰা
10/2/2005 কিনি ৰেজিষ্টাৰ কৰি লৈছে আৰু দখল সমজি লৈ ভোগ দখল কৰি আছে. That means continuously they are possessing according to their own stand. But so,
You are Sunil and Subhas.
no,
I am on behalf of.
The
Sunil.
correct.
Pro registered sale deed.
they
Kini Luana it ought to have been, not Loe. This has been, I've
plaintiffs,
seen.
it is plaintiff suggestion to the other side
Uh,
that
Kini Luana it ought to have been.
প্ৰদৰ্শক তিনি যোগে মূল পাতাদাৰ সত্য নহয় যে প্ৰদৰ্শক মূল পাতাদাৰৰ পৰা 10/2/2005 কিনি ৰেজিষ্টাৰ কৰি লৈছে আৰু দখল সমজি লৈ ভোগ দখল কৰি আছে।
কিনি লৈছে, yes, yes, correct, correct suggestion.
সত্য নহয় সুনীল আৰু সুভাষে
Plaintiff,
প্ৰদৰ্শক
they are the
তিনি যোগে
plaintiffs.
পতাদাৰৰ পৰা 10/2/5
Sunil and Subhas, plaintiff.
Initially.
Correct, he is saying that
ৰেজিষ্টাৰ কৰি লৈছে আৰু ভোগ দখল কৰিছে। মূল পাতাদাৰৰ পৰা ৰেজিষ্টাৰ কৰি লৈছে।
it ought to have been kini loa nai.
সত্য নহয়। So, that is my
These are clerical
আৰু
mistakes.
দখল সমজি লৈ ভোগ কৰি আছে।
This is a civil case, these are clerical mistakes, can be overlooked.
I leave up to your lordship.
Okay, I can start dictating then. We have half an hour's time, maybe more than half the judgment will be over by then.
Lordship.
Koon ase? Mari dia.
So my prayer is that, my lord, appeal may kindly be dismissed.
Mm.
And our said because we suffering so many years despite of purchasing the land, your lordship. So
But according to you, you are under possession, no?
no, my lord, they have dispossessed and now they are possessing. They restricted us to enter into the paddy land. your lord. Paddy
On
or-
10/5, on
that time we were in possession, but after I have mentioned the date.
Okay,
All right, lordship.
I think is there that regarding disposition, there is no evidence.
Lordship, the disposition means, my lord, we have already filed a case.
May I take leave of this honorable?
Yes,
I have
sure,
some-
sure, yes.
Yes. Okay.
Yes.
Some judgment are in my hands if.
Yes, yes, you can give this.
It will.
You have marked the paragraphs.
Paragraph now. Did you?
If you want to submit, we can continue tomorrow, but I will start dictating. And if you want to reply on the judgment, you can ask your senior in the during recess. He will then submit if you want to submit.
Tomorrow?
Otherwise, I will upload the judgment.
In respect of registration or basing on that, we have, and already a act is there. Respondent visa. Respondent will it, yeah? নকৰি আছো তোমাক।
হেৰি এটা দিবাচোন এইটো কি বুলি কয় ষ্টেপলাৰ এটা দিবাচোন এইটো বন্ধ কৰি দিবা ভিডিঅ' কনফাৰেন্সিংটো বন্ধ কৰি দিবা কোনোৱেই নাই
Please, lordship. My lord, in respect to item number 13, my lord, the item was called off before the orders matters was completed, my lord. There was a non-appearance been marked from both my learned friend also and from me. My lord, can a date may be fixed? It's a 2017 matter.
appearance to deed him, no? We'll record your attendance.
My lord, my lord.
Both sides?
Yes, my lord.
এইটো item number 13 কৈ দিবা date এটাও দি দিবলৈ ক'বা
Any date, my lord, any date.
any date
Any,
date এটা দিয়াচোন
as per the convenience, my lord.
all right
I am obliged, my lord. Much obliged.
If I may, my lord, I beg to mention item number 18, my lord. My lord, the counsel for the petitioner, my lord, Mr. Iqbal, my lord, he had to step out of the premises of the High Court due to some personal urgency.
item number 18
Yes, my lord. My lord, ma'am, fixed the matter after 2 weeks. My lord.
so he is not present today or he went away
My lord, he went, my lord. He was here.
the learned counsel Mr. Arborwood
G. Imtiaz, my lord.
G
Imtiaz, my lord.
item number 18
Yes, my lord. My lord, my name is not reflected.
Your name is G. Imtiaz.
Yes, ma'am.
Learned Counsel Mr. G. Imtiaz on behalf of
Mr. A. Iqbal.
Learned Counsel Mr. A. Iqbal has prayed for adjournment. This matter, when do you want?
My lord, after 2 weeks, ma'am.
After 2 weeks. Okay.
Deeply obliged.
It was also held by the learned appellate court of first instance that the exhibit 3, sale deed number 57/2005 has been proved by the plaintiffs host of witnesses, including the vendor, has proved the execution of the sale deed. Whereas the defendants through the evidence as well as the cross-examination of the PW 1, 2, and 3 have failed to show that they were in possession of the suit land for 30 years by constructing a house thereon. Full stop. The PW 3 clearly revealed the PW 3 has admittedly, admitted in his cross-examination that there is no house that the defendants had no house constructed over the suit land, which is an agricultural land. আগতে ডিসকাস কৰিছো না নালাগে মানে তন্তে হেৰি কৰি দিয়া থাকক থাকিব দিয়া The evidence of PW4 was found to be unreliable as and the PW4 has stated of having stood as witness in another case, but this case number was not mentioned, as well as no case record was produced. The cross-examination of PW4. The cross-examination of PW4. It was thereby held that the defendants failed to prove that they had orally purchased the suit land from Surendra Das about 30 years ago. And they have been in possession of the suit land for the last 30 years by constructing a house thereon and residing in the house with their family members, full stop. The decision of the Illinois trial court was thus reverted by the appellate court. Full stop. Arguments on behalf of the appellant. You submit any decision?
Lordship, we don't have anything to submit.
Okay, all right. The arguments are hard, Mr. Yes, well, case number, what is the
D
case
Chaudhary.
number? Huh?
D
D
Chaudhary.
Chaudhary. What is the case number?
Uh,
Huh? 15.
I said 35, 2018.
Had Mr. D Chaudhary, learned counsel for the appellant, and Miss
F Begum.
F Begum, learned counsel for respondent number.
One
F
and two.
Begum, and your name, you want your name to be recorded?
Hussain.
You want your name to be recorded?
No, Lordship.
No. F Begum and learned counsel, Mr.
Hussain.
A Hussain,
Yes, madam.
for respondent number 1 and 2. Arguments on behalf of, arguments for the appellant. It is submitted on behalf of the appellant that that the land, suit land was purchased by the appellants, and the appellant and the original owner, Surendra, who was the original owner? Surendra Das, no? Late Surendra Das were contemplating to execute an agreement, but this did not materialize, and the appellant have no sale deed executed relating, have no sale deed executed relating to transfer of land from Surendra Das during his lifetime to in their favor, full stop. It is contended that the plaintiffs have falsely made out a case of dispossession, and the trial court correctly held that the plaintiffs were in possession of the suit land that the defendants were in possession of the suit land. The trial court correctly held, or the trial court correctly dismissed the suit. But the appellate court erroneously reverted the judgment of the trial court entitled Appeal number 16 of 2016 by relying on the sale deed marked as Exhibit 3. Full stop. The trial court has erred, or the appellate court has erred. The appellate court erroneously held that the defendants failed to produce any revenue receipts, full stop, it is submitted that revenue receipts does, that revenue receipts does not establish ownership and possession over of ownership and possession of immovable property. The learned appellate court has ignored the fact that PW2 stated in his cross-examination that they have a house PW2 affirmed in his cross-examination that they have a house within the house in the suitlet. PW2 PW2 হলো the evidence of the prosecution witness as well as the defendants defense as well as the witness of the defendants have clearly established that PW2 or that the defendants have been cultivating the suit land. But the learned trial court ignored the evidence relating to the cultivation of the suit land by the defendants and decreed the and reverted the judgment of the trial court in TS number 41/2013. Full stop. See that suit was dismissed. Ali, the suit was dismissed. But you see that dismissal order is set aside. You are not given possession or you are not allowed to vacate the suit land or nothing as such. Then why are you pursuing this appeal?
Lordship, I am not aware of the.
I know.
facts.
When will you be able to answer this? I just want to
Lordship, I have to ask my senior.
because you see that there's no order against you. The suit was dismissed and the reversal order, no right, title and interest have not been declared by the appellate court. Why are you pursuing this appeal? I do not understand.
Lordship, Lordship may fix the matter tomorrow.
Tomorrow?
Yeah.
Okay, we'll fix it tomorrow and we will, because this is not against you, you're still under possession. And even you are also possession of a part of it.
They dispossessed us
Yes.
by force.
Hmm.
Thereafter, we filed a suit.
Hmm.
And our suit was dismissed in trial court. That judgment was given against
But
us.
you see that appellate order, I have just seen that.
We have
appellate
filed
order.
appeal
Huh?
in the, we have filed appeal in session court. We have filed appeal in the lower court,
Which was allowed, but you see,
allowed.
uh,
That against they come in the RSA.
the order, the appeal is preferred by the appellants, plaintiff. The judgment and decree passed by the learned Munsif number 1
Lordship,
is set aside.
Lordship,
Judgment and decree is set aside.
set aside.
There's no counterclaim also.
No counterclaim. They have not filed any counterclaim.
Where is the decree? Have you annexed the decree?
Decree annexed for this.
Have you annexed the decree or I can check in the original case record?
Lordship, I.
26 page, your lordship. In their appeal.
Yes, Lordship, 26. Issue 26.
You have filed for right, title and
Lordship. Claim for person. Claim for. And. Right, title and interest, and for cash possession with consequential relief.
no, there's no order for possession. No decree for possession. Even the decree also, there's no decree for possession.
Lordship may fix tomorrow so that senior can.
Yeah, okay. Tomorrow,
Yes,
we'll
Lordship.
take it up. It will leave us an argument. The arguments on behalf of the respondents, the learned counsel for respondents lead stress in our argument. That there is no infirmity in the order, judgment and decree passed by the learned appellate court, and interferences and no interference is warranted, full stop. it has been correctly held by the Learned Appellate Court that the defendants failed to prove that they had any residential house constructed over the suit land whose of no electricity bill or revenue received or any other document substantiating continuous possession for a prolonged period of 30 years have been submitted by the defendants, whereas on the contrary, the plaintiffs have exhibited the sale deed to stop. The oral agreement, the transfer of land by way of an oral agreement cannot be taken into consideration. Full stop. Any immovable property over rupees 100 has to be registered. Full stop. There was no prayer for cancellation of the sale deed marked as Exhibit 3 by the defendants. The learned counsel for the plaintiffs have relied on the following decisions. এইখিনি ইয়াত আছে লিখি থৈ দিব on behalf of J.I. Borgnia লিখা আছে so tomorrow we'll fix this লিখি থৈ দিবাচোন part of argument list tomorrow কাল দি থৈ দিবা এতিয়া দিলে ভাল হ'ব কোনটো টাইমত at 2 yes sir okay 2টা বজাত tomorrow at 2 p.m. obliged. If you have any judgment, you can submit. দুটা বজাৰ পিছত আৰু বেলেগ কেছ নলওঁ বুলি কৈ দিবা দেই কালি হা কাইলৈ আৰু 21 আছিলে ন পাৰবহি
Please, Your Lordship. My lord, the accused petitioner is in custody from 7/1/2024. So till today, he is 1 year, 22 months in custody, my lord. My lord, the petitioner before Your Lordship is a doctor.
There are two petitioners, no?
Yes,
One is a doctor, the other is not.
other is a businessman.
Yes.
So I'm appearing.
Mali is doctor.
Doctor, my lord, I have given the credentials of his profession at, it starts from page 35, my lord. Page 35 is his medical registration certificate. At page 36, my lord, he served in different hospitals of the Army Medical Corps from since October 2019. And he has been conferred with various awards and during his service in the army. Now, after his retirement, my lord, he purchased a plot of land through the deceased in this case, who was a via mediator, and therefore land was, she said, that was in her name. And for that, an amount of more than 1 crore 30 lakhs has been given to that lady who is now since deceased. Now, there was a civil suit pending in respect of that suit land. And even she had around 16 cases against her, including a murder case. So I'm not telling that just because someone has a 16 criminal cases against her, or she is accused in a murder case, that's why someone has a right to murder her. That is not the case.
How many criminal cases?
17.
17.
Including a murder case. I've given those FIRs. And in respect of this doctor, my lord, for 1 crore and 30 lakhs, there is also a civil suit pending at the time of her
did, because that was one, because it was that there is only one eyewitness in this case, her sister, who is PW7. And she has also said that she knows all the accused person because of the previous litigation and all. Now, during the investigation period, my lord, first bail application was moved and it was rejected by this honorable court.
Then you went to the Supreme Court.
No, not that. Then after the charge sheet was submitted, my lord, charge sheet was submitted, then bail was rejected. Then we went to the Supreme Court. I will take your lordship direct, before taking into the FIR, I will take your lordship to the order of the Honorable Supreme Court, that your lordship will find the observation which is important in this case at page
Page number?
128.
Item number 1,
I don't know.
page number 120. Okay.
Paragraph 6. This was the hurdle all along, because your paragraph 6 of page 128. Notwithstanding present order.
Page 120,
128.
128. okay.
Notwithstanding the present order, the petitioners are at liberty to apply for fresh bail after examination of the key witnesses, including the scissor witnesses. Now, how many witnesses are there? Your lordship will look into the charge sheet, my lord. In the charge sheet, your lordship will find the list of witnesses that is at page 90. Now, in the charge sheet, my lord, from page 90 to 92, your lordship will find that there are 32 witnesses.
Okay.
Now, all the witnesses have been examined except the investigating officer. And your lordship will find that after the order of this Honorable Supreme Court, we again moved this Honorable Court for bail. And your lordship's order, will find at page 145. Your lordship will kindly look at page 145.
Okay.
And 145 it starts. Then your lordship will look at paragraph number 5 at page 146. Your lordship has said the petitioner preferred a bail application before this court, but the same was rejected by order dated 7/6/2022 in connection with BA number so and so. On conclusion of investigation, police submitted charge sheet on 26/2022 under section 120B 341 302 of the IPC against the present petitioner. That it was further submitted that the petitioner number 1 preferred a bail application before the court. Then it is the continuation of those bail orders. Ultimately, charge sheet was submitted and charge was framed under section 302/34 IPC. Madam. Charge was framed on 7/1/2023 under section 302, 34, 341 and 34 IPC. Now your lordship will find that in this order, your lordship has said that since out of 32, the key witnesses in terms of the Supreme Court has not been examined. That's why your lordship has rejected the bail application. Your lordship has not discussed the merits or the evidence of that till that time it was corrected. And we also waited till that time. Against this order also, my lord, they went again to the Supreme Court at page 153. The Supreme Court has upheld your lordship's order because the key witnesses were not examined. Now, today we have come only on conclusion of in terms of the Honorable Supreme Court, all the key witnesses have been examined, including the scissor witnesses, madam. If your lordship looks at page 128, your lordship will find that the Honorable Supreme Court has said that key witnesses, including the scissor witness, and your lordship has rightly rejected on the last time, because since the forensic expert, the electronic evidence witnesses were not examined, that's why your lordship has rejected the witnesses. I have given my lord, prepared a compilation of the number of the scissor witness. I can quote of them. Now, if your lordship looks into the witnesses, my lord, as serial number 1, PW1 is the informant, my lord. He is a hearsay witness on the basis of the evidence of PW7. He has filed a FIR. I will take your lordship to that statement. Now, so for PW2 and 3 are concerned, my lord, they are res gestae witness who have reached the place immediately after when the woman was holding her sister's body. Then PW4, 5, 8 to 14, 16 to 20, 22 and 27 are all seizure witnesses. Then PW6 is again a hearsay witness. PW7 is the only eyewitness. Then the recovery witness is the diver, my lord, who dived into the river and recovered the dhow after 9 days of the incident from there. And postmortem was conducted by PW21. Then electronic evidence is PW28 and 29. Official witness, my lord, PW30. He is the OC of the Barpeta Civil Hospital. On the day when the postmortem was conducted, he arranged all those formalities. And the PW31 is the expert FSL witnesses who conducted the serology examination of the deceased. So today I pray that your lordship accept the investigating officer is not has only to be examined, and all the key witnesses and seizure witnesses has been examined. Your lordship will kindly take it into consideration for the bail, because this person is in custody now for almost 1 year and 22 days. So I would like to take your lordship to the evidence of the witnesses, that what evidence actually transpired during the trial of this witnesses. I have made a compilation. The scan copy is there for a ready reference. I have made a compilation of the prosecution witnesses. Now your lordship will first look at page number 1.
Okay.
This is the PW1 who is the informant of this case, my lord. It's a short examination in chief, my lord. Your lordship got it? On 21/3/2022 at around 7:30 p.m., my younger sister Rinima Begum took my elder sister Rupjan Nessa near Binoy Doctor of Bilotori Chowk. Binoy Doctor is not a witness, my lord. After meeting the doctor, Rinima Begum took her driver's seat of a vehicle. Your lordship will say. After meeting the doctor, Rinima Begum is PW7, took her driver's seat of a vehicle, and Rupjan took the seat near to the driver of the vehicle. At that time, Jumma alias Abdur Rahman opened the door of the vehicle. Jumna Abdur Rahman is on bail, Jumma Abdur Rahman opened the door of the vehicle and dragged her out and accused Mogdam hold the neck of Rinima. So in this, even the hearsay witness says that I hold the neck of the Rinima. In the meantime, Jumma alias Abdur Rahman stabbed with a knife at the abdomen of Rinima Begum. This Jumma, as I have already mentioned, is now on bail. At that time, accused Sintu was near the place of occurrence with his bike. Sintu is also on bail. Accused Mogdam and Jumma boarded in that bike, and thereafter all the three fled away. Coming home, Rupjan narrated the story to me, and accordingly, so he has said in his chief that it was Rupjan Nessa, who is PW7, who has narrated the story to him, and accordingly he lost the FIR. Now your lordship will kindly see the cross at the next page. At the time of the incident, I was at my home. Regarding the incident, I was first informed by one Soyod Sikandar Ali. He is not a cited witness, my lord. About 1 day after, I reached the place of occurrence with my sister Bobita Begum. Bobita Begum is also not a witness, and my driver Sofiur Rahman, who is also not a witness. We did not get Rinima at the place of occurrence. He had already been shifted to FMCH Barpeta. Thereafter, we went to FMCH Barpeta and found the dead body of Rinima. I lost the FIR after knowing the fact of the incident from Rupjan Nesha, PW7. The FIR is a printout copy and it was written by one advocate. I met Rupjan Nesha in FMCH Barpeta at about 9:00 p.m. The distance between Barpeta PS and FMCH Barpeta is about 2 kilometers. In Exhibit P1, I did not mention the cause of delay of 1 day in lodging the FIR. He lost the FIR after more than 24 hours, and it was written by an advocate, so he could not lodge the FIR. In Exhibit P1, your lordship will find, I did not mention that Rinima was dragged out from her vehicle by accused Jumma. This is Rinima Begum was an accused in a number of criminal cases. Her own brother admits that this is Rinima Begum was an accused in a number of criminal cases. Rinima Begum might have some enemies. It is not a fact that since there is a civil case, this was the suggestion of the defense. It is not a fact that since there is a civil case lost by Mogdam Ali against Rinima Begum, therefore I filed a false case against Mogdam Ali. It is not a fact that accused Mogdam Ali is not involved with the murder of Rinima Begum and Rinima was killed by her enemies. Now your lordship will see next page. I am not an eyewitness to the incident. I narrated the story in my affair as I learned from my elder sister Rubjan Nessa and from Syed Sikandar Ali. The distance between place of occurrence and Borpeta PS is about half a kilometer. Before I rushed to the FMCS Borpeta, I did not go to Borpeta police station. On 22/3/2022, I lost the FIR at about 11:30 AM. The part played by the three accused persons at the time of the alleged incident are narrated in the FIR. Rubjan was an eyewitness of the incident. Rubjan narrated me the incident. Accordingly, I lost the FIR. Jumma and Chintu are not present in the dock today. It is not a fact that since we have an inimical relationship with the FIR name accused person, therefore I lost the false case against them. It is not a fact that my elder sister Rubjan had wrestled from her earlier statement made to the IO, and as a result, accused Jumma and Chintu had not been sent up for trial. I mean, even accused Jumma and Chintu was not charge sheeted by the investigating officer because Rubjan Nessa has retracted from her earlier statement given to the investigating officer and the 164. I'll take your lordship to those statements. There is a murder case against deceased Rinima. In a case lost by deceased Rinima, court found Jumma and Chintu guilty and accordingly they were sentenced. I was an accused in a kidnapping case registered at Jalpaiguri, Katwali PS. Even he had a criminal case at Jalpaiguri, Katwali. Problem is that, my lord, when you have criminal antecedents of the witness, the court always looks for other evidence other than the witness who has deposed before the court, because they are not to be, say, completely or wholly reliable.
For the trial court.
My lord, but today I am,
This is
yes,
for Decision
Yes.
of the case.
yes. But I am today arguing for bail because prima facie, if your lordship finds that I am not, there is no material after all this evidence, then your lordship may consider my bail, because other persons who are there, they are already on bail. Just because, my lord,
No,
mine,
but
which
but there's nothing against them, Jumma and Chintu.
I'll come to them, my lord. Your
I
lordship,
learned from police that Jumma and Chintu are innocent.
but I'll come now. Now Jumma and Chintu has been arraigned and accused by the court, and they've been allowed to go on bail. I'll come to that, my lord. This is
No,
the
I'm not interested in Jumma and Chintu.
no, my lord. I'm just saying in bail, if by the same nature of allegations, two persons are on bail and one person is not bail, then the law of parity will apply. But if the nature of allegations are different, then the law of parity will not apply, my lord. That's even yesterday or day before yesterday, there's a Supreme Court judgment in which Justice Koteswar Singh was a party, and it was said that normally in bail, rule of parity will not apply. But if by the nature of allegations or the nature of statements attributed, here your lordship will
You see,
say,
there's no overt activity to them. They were standing nearby.
no, they were cool. Jumma, your lordship will say, At that time, accused, again at page 1, at that time, accused Jumma Ilyas Abdur Rahman opened the door of the vehicle and dragged her out and accused Mogdam hold the neck of Rinima. In the meantime, Jumma Ilyas Abdur Rahman stabbed with a knife at the abdomen of Rinima Begum.
Okay.
Who stabbed, my lord? Not me. My allegation, even that neck part also I will come, and even the stabbing part also I will come, my lord. I have just open up the evidence. So it is not that there was no specific allegation against Jumma. Chintu also come. Chintu was waiting in the bike and he took away the as per their version. So it was Jumma who has given that fatal injury to that. And Mogdam, they want to say that it is, I'll come to PW7. Mogdam allegation is that I hold the neck. And the police were trying to prove that I was at the place of occurrence by the this mobile tower location and all. But when we cross-examine the expert witness or the mobile tower location, the dumping witness, they found that our mobile numbers are not there.
Okay.
The prosecution case was that they tried to establish my presence on the basis of that mobile CDR analysis and all. When you cross-examine them, that these mobile numbers were not there. So let me go through it, my lord, one by one, my lord. Then because now since your lordship has said that there was no specific allegation against
No, that Juma,
Abdur
no, I was not talking about Juma, I was talking about Chintu. but-
Chintu also, your lordship say. At that time, accused Chintu was near the place of occurrence with his bike.
I said
Accused
Juma,
Mogdam and
you
Jumma
were
boarded in that
saying
bike.
Juma and Chintu, Juma and Chintu, so I said Juma and Chintu, but I was talking about Chintu only.
Sure, yes. Mala Chintu's role was at that time, accused Chintu was near the place of occurrence with his bike. Accused Mogdam and Jumma boarded in that bike, and thereafter all three fled away.
So you'll read all the 32 witnesses today.
Well, I'll be short because Caesar witness, I will not read it. I'll read almost, I'm completing one. Then 2, 3 are res geste witness, I will read 2, 3. Then 7, then by the CFL, because by that CFL, the witness, they were trying to put the wearing apparels and all. And the
Then if you read all this evidence, and if I decide all this evidence, then it will be like deciding an appeal.
No, I am only trying to say, my lord, that now since the Honorable Supreme Court has said that all the key
No,
witnesses.
it will be like nudging the lower court.
No, my lord, my
If I read all this evidence, it will be like.
No, your lordship will say why your lordship has rejected my bail application. Forget about the merit of the case. Why your lordship has
Only
rejected?
the key witnesses are examined.
Yes, all have been examined. So that's why now.
So now, because I have observed that it doesn't mean that I will take up this case like an appeal.
No, your lordship. Now our case is that since all the key witnesses have been examined, that means there is no question of tampering with the evidence. There is no question of the absconding for bail. There is no question in the last 1 year to 22 months. I have tried to influence any of the witness. There is no such allegation. So my custodial detention at this stage may not be necessary because the next state will come for either then statement defense. Then I have to prepare for my defense witness. That opportunity, just because on the basis of a hearsay witness informant and even Rupjan Nesha, how we have dealt with it cross-examination and how she was trying to improve upon it. This on merit, we don't have a case. But today, my lord, my further custodial detention, is it required for the purpose of the trial of this case, my lord, your lord? Because since all the Caesar witnesses have been examined, all the key witnesses have been examined, where is the question of my further custody? I also have a son who is appearing for his LN12 examination. My other daughter is also a national award winning. I thought recently I'm told that she has won some national award. I have another infant. I have a wife. And just because I had a civil dispute and they know me and they have an inimical attitude towards me, they named it in my FIR. There is no independent witness. And your lordship will surprise that even the whole case of the prosecution was that I have hired a contract killer. In evidence, it has come out nothing. There is no conspiracy theory.
No, see, let's not discuss the evidence at all.
Yes. Then your lordship will, I will only pray that
You
since
see, all the evidence has been recorded. Only IO is to be examined. So let us not discuss the evidence at all.
then your lordship will kindly consider our bail because now we have to prepare for our statement defense. We have to give defense witness. We have to bring all those documents to show that it was only because of those civil dispute and all that I have been detained. And for the last 1 year, what purpose did it serve? If I had tried to influence the witness, if I tried to hamper the, or I have delayed the trial, your lordship will see on I was appearing in this case. If I can show your lordship, the last witness we examined it on 7th of November. Yesterday, we examined the last witness of this case. So today only we are moving for bail. On the last occasion also we did not move for bail because we respect the majesty of this honorable court. That when the court says that it is the key witness, let the key
No, I
witness.
didn't say key witness.
No.
Supreme Court said.
That's right. Now, since the key witness has been examined, the Caesar witness has been examined. So what purpose will serve by keeping me in custody, my lord? Your lordship will say. Initial that hurdle was there, but today there is no hurdle before your lordship to consider our bail application, my lord. With utmost respect, I submit. Is there any hurdle today before this honorable court to grant us bail? Because that hurdle we have to overcome. Because your lordship has earlier rejected also my bail application because key witnesses were not available. And that was rightly upheld by the honorable.
I have not rejected because key witnesses. This is direction from the Supreme Court.
Yes.
That is the reason.
Yes, but now, since I have now that the hurdle of the Supreme Court is overcome, now your lordship will kindly consider our bail because now there is no bar to grant us any bail. That's with utmost respect because 1 year 22 days in custody and there is no allegation from the prosecution. that we had tried to delay the trial. 32 witnesses we have finished, and we did not take a single adjournment. I was there in last witnesses. I personally did the cross-examination of the witness going all the way from here to Borpeta, because I want to finish it up, and I thought that this person, since he is more than 1 year in custody, we should not take time. It will be a crime against him also, because he has also a right to defend himself, my lord. Because these people, my lord, who for some reason or another, just because they have named him in the FIR on the basis of a hearsay evidence, and they have
This person is here, say, this PW7,
PW7 is the sister, my lord. We have also
she is an eyewitness, isn't it?
eyewitness, but we have contradicted her statement. He was time.
Let's see PW7.
Yes, madam.
Only PW7, other witnesses we know.
Yes.
Get it.
Yes. Page 16.
Okay. So this cannot be said to be hearsay witness.
No, I'm not telling. I'm telling about PW1. PW1-7 is the only eyewitness to be said.
That is not hearsay evidence. She
No.
has named Rupjan and Rupjan has given evidence. How can it be hearsay?
No. He
This
is
is
the
evidence under section 60 of the Evidence Act.
No, madam.
Person has said
no, my lord.
is giving the account of
He-
what he has heard.
He said that I am not an eyewitness to the incident. He himself has said that I am not an eyewitness to this. Yes.
Not
So-
an eyewitness, but
yes.
he's a witness. He's a witness, not
Witness,
hearsay.
but he has said on the basis of the statement. So let us go to the
Yes.
statement of the person who says that she was there in the vehicle at the time of the incident, my lord. Let us, for time being, assume that she is speaking the gospel truth, my lord.
Okay.
Informant Harun Ali is my younger brother. This is Rinima Begum was my younger sister. On 21/3/2022 at about 7:30 p.m., while I along with Rinima Begum were about to board in a vehicle, after meeting with Dr. Binoy having a medical consulted, one Jumma dragged Rinima out from the vehicle. That Rinima was laid down on the road while Mokdam Ali held the neck of the Rinima. Jumma stabbed Rinima on her abdomen with a dagger. Thereafter, in the bike of Sintu, both Jumma and Mokdam fled away. I was shouting. In the meantime, a gathering occurred at the place of occurrence. After some time, police came. Police took Rinima to FMCS Borpeta. In FMCS Borpeta, doctor declared Rinima brought dead. Regarding the incident, Harun Ali lodged the FIR. I know Mokdam, Jumma and Sintu since before. Now your lordship will see the cross. The vehicle in which you visited the chamber of Binoy doctor belonged to Rinima. I cannot say the registration number of the vehicle. The color of the vehicle is white. I entered the vehicle first. Then Rinima entered and took the driving seat. The incident of stabbing to Rinima occurred outside the vehicle of the Rinima. So she was occupying the side seat of the driver, and according to her, that incident of stabbing to Rinima occurred outside the vehicle. That is on the right side. The sari I donned was smeared with blood of Rinima. After that accused person had fled away, I embraced Rinima. The sari I wore at the time of the incident was not seized by police. The FIR was lodged by Harun on 23/2/2022. Police examined me on 22/3/2022. I was examined in Borpeta police station. After some days, I was again examined by police. I cannot say the exact date of my examination by police for a second time. It is not a fact that I did not state the facts before the IO what I have stated today in this court. I have her statement also under both times. Her statement was recorded twice by the investigating officer. I'll take your lordship to those statements as well as a 164 statement. It is not a fact that before the incident, I had seen Mokdam for 1 day only, and that day she had the marks on his face. It was during COVID time. It is not a fact that Mokdam was not familiar to me, and since there was a land dispute between Mokdam and Rinima, therefore a concocted story was made out against the accused Mokdam. It is not a fact that Mokdam had paid an advance of rupees 1.13 crores to buy a land from Rinima. That Rinima got one purchaser who wanted to pay more. Therefore, Rinima demanded more sum from Dr. Mokdam Ali than the agreed amount. That regarding that issue, a dispute occurred between Rinima and Mokdam. It is not a fact that I, along with Rinima and other family members, made out a false case against accused Mokdam Ali. It is not a fact that I, along with some laborers, entered into the land against which Mokdam had paid advance to Rinima and started to cut the land, and at the time Mokdam informed police that police came and interfered the matter that Mogdam lost a civil case. So initially, Rinima also tried to grab the family members tried to grab this land, and there was an FIR in that regard. Thereafter, Mogdam lost the civil case against us. That in that case, the civil court passed an injunction order that we also violated the injunction order that regarding that issue we are hostile to Mogdam. Therefore, I falsely named Mogdam before the IO. Prior to the incident, accused Mogdam had made several attempts to hit Rinima with his vehicle, but she did not lodge any FIR before the police. This was tried to be made an exaggeration. Immediately we said that, did you file any FIR in that regard? She immediately said no. It is not a fact that accused Mogdam is innocent and whatever I have deposed today are false and concocted. It is not a fact that Mogdam Ali is not connected with the murder of Rini. Then I know Jumma and Sintu since before. At one point of time, I was residing as a tenant in the rented house of the paternal uncle of Jumma, where Jumma and Sintu used to reside. Some years before the incident of murder of Rinima in an incident, Jumma and Sintu had stabbed Rinima. There was a case in this regard, and in that case, Jumma and Sintu were convicted by the court. Jumma and Sintu are not in the dock today. The witness came close to the accused in the dock present today. I cannot say as to why Jumma and Sintu are not available before this court today as accused. It is not a fact that on 5/4/2022, when police examined me for the second time in the case, I did not state that during my earlier statement made before police, I stated that on the day of the murder of my sister Rinima, I saw accused Mogdam, Jumma, Elias Abdur Rahman, and Sintu and Sofiur Rahman. That I was aware about the quarrel between Rinima and Mogdam Ali. Your Lordship did this line again. I'll take your Lordship to her statement also. It is not a fact that on 5/4/2022, when police examined me for the second time in the case, I did not state that during my earlier statement made before the police, I stated that on the day of the murder of my sister Rinima, I saw accused Mogdam, Jumma, Elias Abdur Rahman, and Sintu and Sofiur Rahman. And I was aware about the quarrel since before between Rinima and Mogdam Ali. Jumma, Elias Abdur Rahman, and Sintu, Elias Sofiur Rahman, that I had suspected accused Mogdam Ali, Jumma and Abdur Rahman, and Sintu, Elias Sofiur Rahman to be involved with the murder of Rinima Begum. That is why I looked their name, that during investigation, I heard that there was some proof regarding the involvement of Mogdam Ali with the murder of my sister. The place of occurrence is a habitable area. Some shops are also located around the place. Rinima's vehicle was racing towards Guwahati on the Borpeta Guwahati through Dolasal Road. The vehicle was parked in the side of the road. The car was parked near the gate of Binoy Doctor. Shops are located by both sides of the road. Rinima was an accused of a murder case. The said murder case is still running. In that murder case, the allegation against Rinima was she had killed the brother of the accused, Jumma. It is a fact that there is a civil case between Mogdam and Rinima regarding the sale of plot of a land. The civil case is still running. In that case, we are substituted as party in that case after the date of Rinima. I cannot say the color and brand name of the motorcycle in which the three accused fled away from the place of occurrence. Police reached the place of occurrence and 1 hour from the assault of the Rinima. I did not inform police, and I cannot say who informed police or how police came to the place of occurrence. At the time of the alleged occurrence, I was present near Rinima. There was a struggling between Jumma and Rinima regarding the closing and opening of the door in which Rinima took her seat before the incident of stealing. Therefore, accused Jumma dragged out Rinima from the vehicle. It is not a fact that since there were various disputes, it is not a fact that since there were various disputes between Rinima and the three accused persons, I have falsely implicated the three accused persons, namely Mogdam, Jumma, and Sintu. It is not a fact that since I could not identify the real culprit of the assailant of the Rinima, therefore I lost a false case against Mogdam, Sintu, and Jumma, with whom Rinima had several disputes. OC himself attended the place of occurrence first and picked the body of Rinima from the place of occurrence and boarded her in police vehicle So, my lord, and now your lordship will see the bail order of Jumma, my lord, who is in custody, who's against them, who's the main allegation.
No,
So, my humble.
who's passed the bail order? Trial court.
We got trapped because we went to the Supreme Court and took an observation that the key witnesses had to be examined. That is our only misfortune, my lord.
Yes.
Otherwise, we would have been. I have seen more serious cases than case where during trial your lordship has granted bail so that it facilitates him to take a proper defense before the court. we got, at that time, we got bound by the order of the Honorable Supreme Court that the key witnesses has to be.
So we also got bound
Or
by the
yes,
order of Supreme Court.
So today I am pressing that since now all the cited witnesses have been examined except the investigating officer. So your lordship will today at least consider
Why
the,
do you think investigating officer is a key witness?
like, if your lordship thinks that the investigating officer is also to be examined before our consideration of the bill.
Why are
we-
you not thinking he is the key witness?
No, madam, no, madam. No, if your lordship thinks that the investigating officer is also a key witness for a moment, I think the next date is fixed for the examination of the investigating officer on 26th of February. We can fix this matter on 27th, and if your lordship desires that, I will also look into the statement of the investigating officer, whether the contradictions were put to him properly or not. Then we can
No,
wait
no,
till
I
27th.
can give you my word on that.
Yes, ma'am.
But if you want to conclude the bail hearing, we'll conclude it today.
No, my lord, my predicament is that, my lord, the person is in jail. The investigating officer, on what line I have to examine, unless I have my client before me, how I will prepare a proper defense, my lord? Your lordship will see, this is the allegation made
Even
by
now,
persons who have
now
all
even
criminal
if
antecedents
you
and.
go before any court,
Ah.
because of the order of the Supreme Court, no court will grant you bail.
But now that hurdle is, your lordship will now at least admit that hurdle is gone now.
I cannot say. IO, you see, you have brought in contradiction. The contradictions have to be affirmed by the IO.
Then I pray, my lord, then let this matter be fixed on 27. On 26th, the IO is fixed. We'll finish it on one
No,
day.
You see, even after examination of IO, won't it be at the conclusion of trial?
No, my lord,
Then
then.
who will grant bail at the conclusion of trial?
No, after the examination of the key witness, if your lordship feels that my further custodial detention is required for the purpose of pre-trial detention, then your lordship will order. But since today, the next date is fixed for examination of the IO on 26, I pray, my lord, this matter may, because this matter is anyway coming before your lordship again, because your lordship has.
No, you see, nowadays it may not come before me because.
Then your lordship will observe, but I pray, my lord, that this.
If I am out of station, it may come up before any other
No,
judge.
unless if your lordship is there, then it will come before your lord. So I pray, my lord, that since
We
I.
hope that you,
Yes.
this matter will always come before me.
Yes,
If I'm
so-
out of station, it may come
Yes,
before
yes.
any other judge. also.
So I pray, my lord, that let this matter be fixed on 27th of February, because I am already in custody. I will finish the investigating officer on that day. Let's see how the investigator,
No,
because,
I won't say on that because if you want to conclude your hearing, you can conclude your hearing.
no, I will pray an adjournment till 27th of February, because the investigating officer, I am told, is fixed on 26th. madam.
Okay, then.
Well, I can take back my paper. I can take back my papers.
Yes, yes, of course.
My lord, regarding my petition, my lord,
Hmm.
most unfortunate, this particular petitioner, my lord,
Hmm.
he,
Did you also go to Supreme Court?
yes, my lord, that is why, my
No,
lord.
no.
But my lord,
What
My-
is his name? Mohibul.
Mohibul Haq, my lord. And my lord,
And
I would rather
we have the
submit,
same order by the Supreme Court.
yes, my lord. So what my,
So you see now.
no,
you-
I understand, my lord.
Now he has prayed for adjournment.
Yes, my lord, then together, my lord. But what I am only just indicating that the order of the Supreme Court is not a predicament, rather it's a relief that has been granted to the petitioner, because the wordings clearly said that notwithstanding the present order, because they were directed to appear, my lord, the petitioners are at liberty to apply for fresh bail. The liberty was rather granted to us that after examination of witnesses, we have the liberty to apply afresh for bail, my lord. So it's not, my lord, an adversarial order. Rather, it is, my lord, given liberty to us to apply for fresh.
So you do not have that catch that key witnesses have to be examined in that order?
Yes, same order, my
Or
lord.
same order?
Same order.
You see, key
Yes,
witnesses
ma'am.
have to be examined.
Yes, I'm just informing the honorable,
Yes, yes.
my lord. Otherwise, my lord, actually, I have a very good case. Nothing is there against me, my lord. Entire evidence, my lord. Till date, my lord, 32 witnesses have been examined, my lord. Nothing has come up against, my lord, no material against this petitioner, my lord. And only.
No, you see, that cannot be
Court-
decided by this court.
Yes, my lord. That is
During
my only.
bail application, whatever has
Same
surfaced
date,
in
my lord.
evidence or whatever has not surfaced cannot be decided.
Yes, my lord. Yes. Same date, my lord, both the cases.
We have the LCR, no?
Yes, ma'am. LCR is there, my lord, updated,
Parties are represented
updated
With
status
this
report.
matter after 27th, when did he say?
27, my lord, 27.
20, huh? 20?
26th is the
27. Okay, 27. Let's just matter on 27.
27. Deeply obliged. my lord.
Item 22.
Are you ready? Both the parties are ready?
This one.
Okay. Yes.
My lord, on the last occasion, your lordship's query was as to the maintenance, my lord.
I don't remember.
Yes, my lord, that was the one of the query, and second query was that what is the amount of my salary? So that two questions were instructions were, my lord, directed to be taken on that regard. My lord, I have
Teacher?
not-
Tutor?
Tutor,
Okay,
tutor, my lord.
now I remember.
It was the previous one. Sorry.
So what is your salary?
Salary is so far as the statement of this month, my lord, January, prepared by the headmaster.
Hmm,
It appears, my name appears in serial number 3, my lord.
hmm,
That is Jamaluddin Ahmed,
hmm,
science tutor,
hmm.
fixed pay per month 14,000.
Okay.
So that as on date, my lord, that is my salary.
That earlier contractual basis 8,000.
12,600.
I understand. This is the same group, no? Earlier on contractual basis, they were getting 8,000. They are not
My-
regular, no?
my lord.
Are they regular?
The tutors, my lord, they have.
They are not regular, no?
They are not regular.
Earlier they used to get 8,000, now they are getting
My lord, my lord.
15,000, I
Yes,
believe.
my lord.
Here
So-
14,000. Okay.
14,000. So that is my,
Got it.
that is
So
my,
you want a reduction?
my lord.
How
Because
much? How much?
otherwise,
The
my lord,
amount of mohar, my lord, perhaps my lord, in mohar.
Oh,
my lord,
more, oh.
Yes.
it is maintenance is
Because,
not
my
in
lord,
dispute, my lord,
in
here.
maintenance case, my lord, he is not paying the maintenance also, my lord.
Hmm.
Around 3 lakhs is pending in the maintenance case also. He is not paying that amount.
Oh, mohor, you want a reduction in the mohor?
He
My
can,
lord.
he can pray for reduction in the mohar amount, my lord, before the competent court, my lord. But
Hmm.
this is a case, my lord, where, my lord, he is, my lord, disputing the mohar amount, my lord.
Hmm.
Perhaps this is not permissible, my lord,
Hmm.
for reduction of the mohar amount.
Yes, yes.
And my plea was that, my lord, for a moment, if your lordship is pleased to page number 66, madam. Why I am saying that the amount was manipulated. So that your lordship will find at page number 66. Because if it had been actually fixed on 500, 5 lakh
That was
70.
decided conclusively, no?
My lord. But the fact is that, my lord, the court relied upon the deposition as well as the documents which was prepared by the party, which was prepared by the party who was also a participant in the commission of the offense, my lord. Because it was the Qazi, on the basis of the deposition of the Qazi, that the matter was decided. But my allegation against him is expressly that, my lord, he was a participant in the manipulation, my lord. And so far as the manipulation is concerned, my lord, it is in the marriage application form. That was the first document I signed, my lord.
You cannot accuse somebody of a criminal act without bringing up a criminal case against him. Have
But
you brought up any criminal case against him?
my lord, that was filed, my lord, but that has also been dismissed, my lord, because the court directed me to produce the original of the.
So now in this case, how you will have to prove beyond reasonable doubt or on preponderance of probabilities?
That is why, my lord, for a moment, can I take your lordship to page number 66? My lord?
No,
This is the document I relied upon,
no, we will hear it finally. We'll list it for hearing.
my lord.
I'll admit it and list it for
My
hearing.
lord.
Okay?
My lord, he is not paying the maintenance as well as the mohar amount, my lord. I am starving, my lord. I have a son, my lord, he is studying in class 7.
Today, do we have time to hear it
My lord, there
completely?
is nothing in this case, my lord, to decide, my lord. He only thing he disputed the amount. He
Hmm.
said that it was 51,000 and my lord,
No,
the
but
wife said,
according to you, it is very easy. Let us see, will you able to complete it in 1
Yes.
hour?
yes, my lord, wouldn't happen or perhaps my lord will complete.
But even if that Honorable, if your lordship is pleased to make some another, that also we can accommodate, my lord, because your lordship is also taking,
I know, I have taken up
Yes,
too many
madam.
hearing today.
my lord. So that, and another date may be fixed. my lord, at-
For
at-
admission hearing only in the next week, madam, in that case, madam, for admission hearing in the next week,
Next week we will dispose it off.
my lord,
My lord.
Yes.
for final proposal.
List this, both the parties are represented, list this matter, for, final disposal at the stage of admission on,
Fifth.
okay.
But in that case, my lord, if I can satisfy your lordship,
You'll have to satisfy,
therefore, my lord, if,
otherwise it will go against
okay,
you.
my lord,
You come prepared.
my lord,
My lord, he is,
And that same day I'll pass the order
My
at the
lord.
judgment.
my lord.
But
he is challenging the, my lord, findings of the Learned Trial
Fifth,
Court.
okay, fifth.
Okay.
Please be prepared,
My lord,
come with judgment and everything.
my lord, my
Because I'm finding, I'm more inclined towards this
my
submission.
lord,
It's up to you
my lord.
now.
Obligement.
Obligation.
May I please your lordship?
Mm.
My lord, in connection of this FAO, IA is filed for condonation of delay, my lord.
Mm.
211 days are delayed, my lord, in filing this appeal against the final order dated 19/12.
What about the other side?
Other side is, my lord, I have.
211 days,
taken-
we'll have to hear the other side, see?
Yes, my lord, other side. I have
Any
taken
notice has
steps.
been served?
Notice is served, my lord. On 4/12/2025, I have taken steps for service notice to the respondent.
But you see, 21/1/2026, no service report,
Service,
office note, no service report.
but I have the Talaban, I have copy.
No, steps have been taken. Nobody is saying that you have not taken steps.
Yes, my lord.
Notice has been issued to sole respondent, but no service report. We'll have
So-
to wait for service report.
So time may be given for awaiting the service report.
Yes, yes.
And with the office note next date. fixed by
Office
the-
note is already there, no service report. Office note dated, likha. Office note dated 21/1/2026 indicates that service report has not yet arrived. Await for service report, list the matter after 1 week. Miss BRA Sultana is present for the applicant.
Data টা দিব নেকি after 1 week হলে?
দি দিব পাৰি ডেটাটা? No, নাহিব. 4th February নাহিব. Second week of দি দিম. 4th February নাহিব.
11 February.
11 February. We'll take up some other day.
My lord, but date may be fixed, my lord.
Yes.
First week of March, my lord.
First week of March.
My lord.
Okay. Parties are represented. This is an old pending case. This matter for hearing positively on first week of March or date of the option. 5th March.
Deeply obliged. my lord.
Fifteen to হৈ গ'ল নেকি? 15 to হৈ গ'ল? Huh? 15 to. কোনটো? কৰিলো যে,
Lordship, you engage counsel is in another court. The item may be fixed up for another date.
Another day, okay. Learned Counsel, Miss R. Chaudhary is busy in another court. List this matter on. This is a new matter. We can list it in the month of March also. March or December?
Lordship, is the timing possible for today?
No.
10 March.
RSA hearing, no. 10th March.
Lordship.
New matter.
May please your lordship, from appellant side, nobody is there.
Appellant is not represented. Earlier, he was present or not?
In earlier matter, earlier that he was.
No, today, not today. Today was he present?
I have not seen lordship.
Appellant is not represented today. Respondent is represented by Mr. S.K. Sarkar. List this matter for hearing on data that di দিব পাৰে. this is matter for hearing after,
10
uh,
March, which one? 10 March?
after 3
10.
weeks, huh?
10 March.
You want a date?
Yes.
You are the claimant?
No, respondent.
Hmm? Oh,
Respondent.
matrimonial appeal. Okay,
Matrimonial.
okay. The 10th March,
10 March or after 3 weeks?
after 3
Three.
weeks.
Highly obliged, Lordship. Highly obliged.
আর কি আছে নি? নাই।